Good morning, Deputy Milton. Can you see me and hear me?
Yes, I can.
Okay, sorry, I'm just having a interesting technical morning. So, all right. Good morning, ladies and gentlemen. My name is Judge Lal. I do apologize for the delay, but let's get started with our state all-purpose with the State Court of Fulton County for today, June 13th, 2024. This is a list of criminal misdemeanor cases in which individual defendant cases have already been accused, bonds have been set, and today we're going to get a status of those cases. Either the defendant, with the assistance of counsel, has decided to accept a plea recommendation and enter a plea of guilty or no contest, or has decided to have a trial, and in which case a not guilty plea will be entered and the case will be further noticed for trial. If you are a defendant accused of one or more misdemeanor offenses, please remember that you have a right to remain silent. Anything that you choose to say during the course of this virtual court proceeding, your statements can and will be used against you in the treatment of your case. You have a right to an attorney. If you cannot afford one will be appointed to represent you. Courtroom 2 or ACDC, who shall we begin first?
Add-on 3 and 4, Ms. Shara Lindley.
All right, Ms. Shara Lindley. This is the add-ons case 23 CR 40018 and a bench warrant 24 FTA 658. Ms. Lindley, you've been accused of tampering with evidence from June 23rd, 2023. You've been advised of your right to remain silent, and your attorney is it Ms. McLeod?
Me, Your Honor. Good morning.
Good morning. All right, this is add-on 3 and 4. All right, Ms. McLeod, how are we proceeding?
This is going to be a negotiated plea this morning, Your Honor.
All right. Ms. Lindley, may I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. All right, Mr. Ham, good morning. And yes, sir, what's the recommendation?
That's me, Your Honor.
Oh, Ms. McCarthy, sorry. Yes, Ms. McCarthy, good morning.
Good morning. How are you, Your Honor?
Fine, thank you.
The state's recommendation is time served. I believe now that would be 36 days, credit for time served 19 days, if my math is correct. And then the FTA cross.
Okay. All right, thank you. Ms. McLeod, do you stipulate to the factual basis, venue, and ID?
Your Honor.
All right. Ms. Lindley, have you consumed any medicine or alcohol?
No.
And have you understood the proceeding so far?
Yes.
Are you satisfied with your attorney?
Yes.
And has it been explained to you that if you decide to enter a guilty plea, you would have to give up your right to a trial? You will not get the chance to go back to court to confront your accuser and have the prosecution prove the charges against you beyond a reasonable doubt.
Yes.
All right. Have you understood your attorney's explanations?
Yes.
And how do you plead to tampering with evidence?
Guilty.
Your sentence is going to be to serve 36 days, credit for time served 18 days. And that concludes your sentence. The bench warrant matter is null pros. Thank you.
Thank you, Your Honor.
Mm-hmm.
And that concludes my business before the court this morning. May I be excused?
Yes, thank you, Ms. McLeod. Please make a note to send any plea paperwork to Ms. April Champion.
I have it prepared, so I'll just go ahead and send it to Ms. Champion.
Okay, you have a good week then. Thank you.
Thank you.
Ms. Deputy Milton, do you have another one?
Yes, I have Angel Jones. position 16 and 17.
And that's on the SAP calendar?
Yes, the rest of them is on the SAP.
Okay.
Morning, Your Honor.
Good morning, Ms. Vigiletti. All right. We have Angel Jones at AC/DC accused of loitering or prowling, 24 CR 25B. And she's got a bench warrant, 24 FTA 655. Ms. Jones, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. May I place you under oath? Do you solemnly swear and affirm the testimony you present will be the truth to the best of your knowledge? You need to say yes or no.
Yes, ma'am.
Thank you. All right. Mr. Ham, what's the recommendation?
Yes, Your Honor, the recommendation on position 16 is 12 months to serve 45 days, credit for time served 20 days. Balance suspended and to stay away from 1950 Sullivan Road Southwest, and to have no further contact with Diane Hannon, HANN. As it relates to position 17, the state will move to null press position
And
7.
what was the name of the victim? Diane King?
HANN.
Repeat again. I'm so sorry. The audio is a little low.
Sure, it's Diane Han, HANN.
Oh, HANN. All right, got it. Thank you. Ms. Vigiletti, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
We do, and I just want to make sure Ms. Jones is clear. I don't remember if I explained this jail's double credit policy or not, but this is the 3 more days in jail that we talked about.
So it was 12 months to serve 45 days, credit for time served 20 days?
Yes, Your Honor.
Okay. Ms. Jones, have you consumed any medicine or alcohol?
Not this morning, no.
Please speak up.
No, not at this moment, right now.
All right. And have you understood what's going on in your cases?
Yes, ma'am.
Are you satisfied with your attorney?
I am satisfied with very, very much with it, yes, ma'am.
All right, very good. And Ms. Jones, if you decide to plead guilty to loitering or prowling, you would have to give up your right to go back to court and have a trial in front of a judge or a jury.
Yes,
You will
ma'am.
not get a chance to confront your accuser, challenge the evidence brought against you, and have the prosecutor prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, I am.
Please speak up.
Yes, I am
How do you plead to one count of loitering or prowling?
guilty, ma'am.
Your sentence is 12 months to serve 45 days, credit for time served 20 days. You have an additional few days to serve at the jail before you are released. Once you are released, you cannot return to 1950 Sullivan Road in Atlanta, Georgia, and you are to stay 200 yards away from Diane Hannon. Understood?
Understood.
Thank you.
Thank you, Your Honor.
And the bench warrant is null pros.
Next, we have position 3 and 4, Ms. Collier.
This is State versus Kristen Collier, accused of a driving incident, having an expired tag, failure to have license on person, an expired license, and a suspended or revoked license. And she has a bench warrant. The bench warrant is 24 FTA 695, and the original case is 17 CR 28480284889E. Looks like the traffic matter was from April 2016. Ms. Collier, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. May I place you under oath for purposes of plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do, Your Honor.
Thank you. Mr. Ham, what is the recommendation for Ms. Collier?
As it relates to position 4, for expired tag, essentially the state's recommendation is time served. It's been 42 days, or it's 42 days, credit for time served, 21 days, which is essentially time served. For count 2, fail to have license on person, that is also a time served plea. 42 days, credit for time served, 21 days. Expired license, suspended or revoked, count 3. It's also a time served plea. 42 days, credit for time served, 21 days. As it relates to position 3, the state will move to null pros position 3.
All right, so it's time served on all 4 charges?
2 charges, Your Honor. It's time
All
served,
right.
3 charges.
Ms. Vigiletti, is your client pleading guilty to failure to have license on person and expired license as well as suspended or revoked license?
So it's my understanding that, according to the offer, I believe there's just 3 counts. No license on person and expired or revoked license. Or
I've got
suspended-
4 charges on my calendar.
Oh, maybe I misread the calendar, but it does seem that those 2 should merge, but let me take a look.
Yes, it's a
So-
total of 4 charges, Your Honor.
Thank you. So, Mr. Ham, if she pleads guilty to suspended or revoked license, even though the incident was from 2016, this is automatically going to trigger a 6-month license suspension from this point onwards.
State will move to null pros.
The state is going to null cross the suspended and revoked license. Would that be correct?
Yes, Your Honor.
All right.
Thank you, Your Honor.
And then which one do you want to go with, Mr. Ham? Failure to have license on person or expired license? Because one has to merge into the other.
We're going with the expired license, Your Honor.
Okay. So we're going to we're going to merge the expired license into the failure to have license on person. So she's pleading to 2 charges, expired tag and failure to have license on person. Would we all be in agreement about that?
Yes, Your Honor.
Okay. Ms. Collier, you're only pleading guilty to 2 charges, and that would add points to your driving history, even though it's from 2016, but it will not trigger a license suspension. Do you understand?
Yes, Your Honor, thank you.
Okay. So with regards to these 2 charges, if you decide to, and sorry, Ms. Vigiletti, you did stipulate, correct?
Yes, Your Honor, and I did just want to state for the record, I know it's going to be null pros, but Ms. Collier was in custody in Bucks County on March 26th, so that is why she missed court. Just wanted to state it for the record in case, you know, it ever comes up in the future. I understand it'll be null pros as part of the plea.
Okay. Ms. Collier, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood so far what's going on in your case, even with the changes?
Yes, Your Honor.
And are you satisfied with your legal services?
Yes, Your Honor.
If you decide to plead guilty, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not be able to confront your accuser, as well as have the state prove the charges against you beyond a reasonable doubt. Has that been explained to you?
Yes, Your Honor.
And are you giving up your constitutional right to a trial?
Yes, Your Honor.
How do you plead to an expired tag and failure to have license on person?
Guilty.
The other 2 charges will be null pros as well as the bench warrant. Your sentence is to serve 42 days, credit for time served 21 days. That concludes these 2 cases. Thank you.
Thank you.
Thank you, Your Honor.
Next, we have position 26 and 27, Ms. Scott.
Felisa Lachey Scott is accused of misdemeanor obstruction of an officer and misdemeanor possession of marijuana under case 22 CR 4073E. Ms. Scott, your second case is a bench warrant for 24 FTA 690. Ms. Vigiletti is your counsel, and you've been advised of your right to remain silent. And Ms. Vigiletti, are you filing a waiver of arraignment?
Yes, Your Honor.
Okay. So, Ms. Scott, you are entering a not guilty plea, and your case is going to be further noticed for trial.
I do also would like to make a bond request this morning, Your Honor.
Go ahead.
I am so sorry. I have notes that are not responding on my computer here.
Welcome to my world.
Yes, I know this case. I know Ms. Scott. We talked yesterday. So, Ms. Scott was, arrested for this, incident on April 20th of 2020. This is a bind over case. It looks like it was bound over in November of 2020. And, what this comes down to is basically she had no idea. The case was accused more than 2 years later because of COVID. So the reason she missed court is she just didn't know. She was unhoused at the time, so, she didn't have an address. And she actually did have another open case in Fulton County at the same time that she was showing up to court for. She was in touch with her attorney for and was able to resolve in Superior Court, which is, very strong evidence that if she had known about this, she would have shown up. But because she was taken, I think, to Grady and given a citation, that she doesn't actually have a memory of receiving and then is unhoused. She just didn't receive notice of this May 22nd, 2023 court date. I would like more information on this case before advising her regarding a plea because we don't have, there's some things that are missing. There's a few sort of red flags where I just would like to know more about order of operations with her interaction with police. I'm not quite sure what their reason was for approaching her in the first place. She was sleeping in a car. She wasn't an unhoused person. She wasn't bothering anybody.
May I ask, what's the other case number?
I am so sorry, Your Honor, my computer is completely frozen
Okay,
here.
that's fine. What are you asking for in terms of bond?
So we're requesting a signature bond today with the understanding that I do have a stable mailing address for her right now. And she did show up to court on this other case at the same time. She is the person who shows up to court.
All right, let me ask, Miss Mokaki, any objection to a signature bond through the jail?
No objection to a signature bond, Your Honor.
Right, on the obstruction, it's going to be 500. On the misdemeanor possession of marijuana, it's going to be 100. Total bond is 600, signature bond through the jail. Miss Scott, you have now three active cases with the State Court of Fulton County. So please, when you respond to your other case, please make sure that you let the prosecutor know or your defense attorney know that you have three active cases. Do you understand?
Yes, ma'am.
All right. Make sure that you do not get arrested again and come back to court when summoned. Miss Vigiletti, please make sure that her address is on Odyssey. You can send a text or a chat to Miss April Champion to update her mailing address.
I will. Thank you, Your Honor.
Thank you. And this is further notice for trial. Next case, please. ACDC, I think we are concluded.
Yes, Your Honor. Thank you for everything.
Thank you. And I apologize for the delay. Take care. Courtroom 2, who do we have next, please?
Company position 5 and 6, Mr. Garland, Jacob Garland.
It's a negotiated plea, Your Honor.
All right, sir. This is State versus Jacob Andrew Garland, 22 CR 5829D. Would that be correct, Mr. McLean?
Yes.
Okay. And Mr. Garland has two cases. The first one stems from a traffic incident of July 2021. The charges are driving under the influence of alcohol less safe, following too closely, no insurance, and driving while license suspended or revoked. Position 6 is a bench warrant 24 FTA 680 from December 9, 2022. Mr. Garland has been advised of his right to remain silent, and his attorney is Mr. McLean. Mr. Garland, may I place you under oath for purposes of the plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Ma'am.
Repeat.
Yes, ma'am.
Thank you. Mr. Ham, what is the state's recommendation?
Yes, Your Honor. As it relates to the DUI charge, let's say state's recommendation is 12 months, serve 40 days, credit for time served 20 days, balance to be served on probation, to complete 40 hours of community service, a DUI risk reduction class, alcohol, drugs, evaluation, any treatment deemed necessary, Alcohol Anonymous 2 times a week, and 1 victim impact class. As it relates to count 2, following too closely, the state's recommendation is 12 months to run concurrent, 12 months probation, run concurrent with count 1, and to pay a $265 fine. For count 3, no insurance, the state's recommendation is 12 months probation to run concurrent with count 1 and to pay a $350 fine. For count 4, driving while license suspended or revoked, state's recommendation is 12 months probation to run concurrent with count 1 and to pay a $500 fine. As it relates to position 6 on the calendar, the state will move to no cost.
Thank you. Mr. McLean, are these the terms to which your client has agreed, and do you stipulate to the factual basis, venue, and ID?
They are, for those purposes, we do. Your Honor, this is a happy solution to the case that was on before. This is the fellow that had the June 18th hearing in another state, and this will cause him to be able to make that hearing. This is definitely what he wants to do.
All right. And Mr. Ham, was there a fine for the DUI?
It was not a fine listed for the DUI.
There was no fine listed for the DUI. Would that be correct? Okay. Mr. Garland, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings in your 2 cases?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
If you decide to plead guilty, you would have to give up your constitutional right to a trial in front of a judge or a jury. You would have to give up your right to confront your accuser, challenge the evidence brought against you, present any defenses and arguments you may have, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
You understand that pleading guilty to these charges will add points to your driving history, and that the charges will also suspend your driver's license for a minimum of 1 year.
Yes, ma'am.
And you're not allowed to drive for 1 year. Do you understand that?
Yes, ma'am.
How do you plead to driving under the influence of alcohol less safe, following too closely, no automobile insurance, and driving while license suspended or revoked?
Guilty, Your Honor.
On the DUI, your sentence is 12 months to serve 40 days, credit for time served 20 days. The remainder of the time will be on probation. Are you traveling immediately?
Yes, ma'am. Well,
And when are you planning to return?
Probably Wednesday or Thursday of this upcoming.
I need a set date. If you return on Wednesday, you have to report to probation on Thursday.
What's the date of next Friday?
Next Thursday is going to be the 20th.
So it'll be the 21st.
No, 21st, they don't take new probation cases.
Right. I believe he's going to be coming back to Georgia on the 21st after the 18th in the other state.
All right. His report date to probation will be the following Monday. And that would be the 24th.
Very good.
So, Mr. Garland, your report date to Fulton County Probation is June 24th before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. When you report to probation, you will have to complete the following conditions. With regards to the following 2 closely, it's concurrent to count 1 and the fine is $265. With regards to no insurance, it's concurrent to count 1. The fine is $350. With regards to the driving while license suspended or revoked, it's concurrent to count 1, and that's a $500 fine. And with regards to count 1, the DUI charge, your sentence is 12 months to serve 40 days, credit for time served 20 days. You should be released within the next 24 hours. While you're on probation, you will complete 40 hours of voluntary community service. You have to complete a minimum of 5 hours per month and 5 hours every month thereafter. You're also to complete a risk reduction program, which must be done within 30 days of being released. An alcohol and drug evaluation and submit yourself to any treatment that must be done within 30 days of being released. For the rest of the year while on probation, you will enroll in an qualified AA program and attend those classes twice a week. You will also attend and complete a 1 victim impact panel. Your license is suspended for 12 months. You're not eligible for reinstatement within the next 12 months. Or with regards to your fines, please make sure that you make a minimum payment of $100 per month and every month thereafter. Any questions, Mr. McLean?
None, Your Honor. Thank you.
All right, thank you. And his bench warrant is null pros. Thank you.
Next, Your Honor, is going to be position number 8, Mr. George Holiday.
This is State versus George Holiday, accused of reckless conduct from May 21st, 2024. Mr. Holiday, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Your accusation is 24 CR 3237G. I understand that this is going to be a non-negotiated or a negotiated plea. So, Mr. McLean, what's the status?
It will be non-negotiated, Your Honor.
All right. Mr. Holiday, please raise your right hand. Do you solemnly swear and affirm the testimony you provide for the plea will be the truth to the best of your knowledge?
Yes, ma'am.
All right. So I'm going to hear from the prosecutor, and then I will hear from your attorney. I will make a decision as to which recommendation I will accept, keeping in mind that I can reject either one and have the case further notice for trial. Mr. Ham, what's the factual basis and the recommendation for Mr. George Holiday?
Yes, Your Honor. This case stems from an incident that occurred on May 21st, 2024 at approximately 1:31 in the afternoon. Incident location was at 3175 College Street in East Point, located in Fulton County. Incident involved the defendant's neighbor. Apparently there was a dispute about her vehicle being parked near his grass. I think he wanted her to move her vehicle because he was about to cut his grass at that time. The defendant at that point began to cut his grass and purposely blew grass onto the vehicle, which belonged to his neighbor's caregiver. The neighbor's caregiver and the owner of the vehicle is spelled Alicia Domain, Alecia, last name Doman. Being frustrated, the defendant went into his backyard in an attempt to intimidate his neighbor, Ms. Milton, and her caregiver, Ms. Domain, began discharging his firearm into the air so that they can remove the vehicle. Police was able to find at least 2 defects as it relates to the defendant in this case. Or, excuse me, 2 defects fired from the gun used by the defendant in this case. Based upon the incident, the fact that this was a gun used against the elderly neighbor and her caregiver, the state's recommendation is 12 months to serve 180 days, credit for time served 22 days, the balance to be served on probation, to take a gun safety course, to have no firearms, to complete 40 hours of community service, and to engage in a 12-week anger management program. He has no felony history or any criminal history. I believe he used his first offender.
Mr. McLean?
What were the defects? I probably missed that in the report.
Give me a second. Let me pull it back up.
I'm sorry, I think Mr. Ham's, Mr. Ham?
Yes, Your Honor.
Oh, were you responding to Mr. McLean's question?
I believe so, Your Honor. 2 shell casings were found in his backyard, and he's alleged to have shot 4 times. So 2 shell casings was found in his backyard, and it's located on the warrant, that information.
All right, thank you. Mr. McLean, did that answer your question?
Yes, Your Honor.
And how are we proceeding from the defense side?
Your Honor, he'd like to ask the court to consider piling on more requirements in exchange for the concept of fewer, possibly down to 0 extra jail days. This calculation would result, we understand that gun charges We've had a lot of experience. We understand that oftentimes gun charge offers from the state are involving extra jail days. In the past, sometimes they've been more than the 180 that we have here, which is equivalent to 90 days in jail. This would cause 68 additional jail days starting today. Your Honor, and I and Mr. Ham can all imagine what the arguments would be, especially the closing arguments, in a reckless conduct case based on somebody shooting a gun in their own backyard. But this wouldn't be a reckless conduct case, I don't think, if there weren't the preceding conversations about grass on a car, where was the car, and that sort of thing. So the state has correctly put the thing in context in order to charge him, and Mr. Holliday understands the point. I don't think that 68 days is going to be necessary to drive the point further. There is a frustration level that he had. It was wrong for him to do it. In the absence of the context, it would have been arguably legal for him to do that, and he is taking responsibility for the charge that is levied against him today. So he's asking the court to take that into consideration. He's already agreeing to 40 hours of community service, taking the gun safety class, 12 anger management. If there's anything that anybody can think of to add to that to justify time served as the jail portion of the sentence, or at least cutting that 68 in half, that would be welcome. There is a Mr. Busey or Busby, I think, who is
Yes, we do have someone who's going to speak on his behalf.
And
I have someone on iPhone, if you'd like to unmute and start your video.
And I told him when I conversed with him earlier, I said, you know, it's a plea bargain and we're in the sentencing phase. I'm not sure that I'm going to be restricted simply to asking you if you know his reputation for honesty in the community, and that question only, but the court is free to rule on that, of course. Otherwise, he'll just say he's known him for a couple of years and is open for questions.
All right, sir, the gentleman in the red shirt, can you please pick up your device and put it in front of your face? Are you driving?
I actually had pulled over.
All right, so he's driving. Please remove him from Zoom. He's driving. Please remove him from Zoom. Thank you. All right.
Sorry,
Okay.
Your Honor.
So, Mr. Ham, what's your opposition to the defense's recommendation?
The state's opposition to that recommendation is the fact that this was used to intimidate an elderly individual and her caregiver simply because the car was parked near his grass. It wasn't used for any other purposes but to intimidate those individuals. So based upon that, Your Honor, we're sticking firm to the state's recommendation.
All right, thank you.
This is a point that is so small, maybe I shouldn't mention it. He says the car was actually parked right on his grass, but he shouldn't have.
Do you think it makes a difference, really, Mr. McLean? Really?
Well, I'm just explaining why the conversation started. I'll put it that way.
I mean, no, I mean,
He knows
I'm not
that.
gonna go touch that with a 10-foot pole.
Your Honor, I'll put it this way. He understands that he should have cut his grass in a clockwise direction so that the side discharge would not have blown.
No, sir. I think even you are missing the point. This is a piece of a vehicle encroaching upon someone's grass. Even if I assume that the neighbor parked her entire car on Mr. Holliday's front yard.
Correct.
I am never, ever going to condone the discharge of a firearm over such a dispute. Never, ever. Okay.
No, I'm not
So
saying.
let's move on to maybe a more plausible argument.
No, that's not what I'm saying, Your Honor. I'm saying that that was, I understand what the charge was, and he's accepting the responsibility for the charge as charged. But what I'm saying is it's the context of the previous conversations that causes the state to be able to make such a charge. If in the absence of anything going on between them that morning, a person had fired 4 shots in his own backyard, this wouldn't be a reckless conduct case. It's all in the context.
Okay, let me ask you then, is the defendant alleging that the neighbor had threatened him with a firearm? Or
No, Your Honor, he's not alleging that.
okay,
He is not.
all right. Miss Lewis, is that individual in the red shirt back on the Zoom?
No, ma'am.
Okay. With regards to the recommendation, yes, and as Mr. McLean is very familiar, I don't condone these kind of incidences, especially involving firearms. But I also am taking into consideration that he doesn't have any felony convictions. Would that be correct? Okay.
I believe that's correct.
Mr. Holliday, I will reduce this to 90 days and to serve 22 days. But in the alternative, like you said, piling on, you'll be required to have no contact with the neighbor, which means that when your neighbor or the caregiver are outside the house, you are required to be inside. You are not allowed to step outside.
Yes,
That
ma'am.
what's mean. And then when you are outside your house, you have to stay 200 yards away from your neighbor and have no contact with this person. Unfortunately, I'll get the name from you shortly, Mr. Ham. My recommendation also, in lieu of cutting your jail time by half, is that you are to do 240 hours of voluntary community service with a minimum of 50 hours per month. And you are to attend and complete 24 weeks of anger management classes. Any and all firearms that you possess shall be surrendered to the police for destruction. You're not allowed to own a firearm while you're on probation. And you are to attend and complete a gun safety class.
Yes, ma'am.
And basically that's it. That must be done within 30 days of being released. Mr. McLean, will your client accept these terms?
Yes, Your Honor.
All right, he will be on active probation every month. He's required to report every month. Do you understand, sir?
Yes. And may I ask how long will I be on probation?
Well, the calculation would be 12 months minus the,
3 months minus the 90 days.
well, they only subtract the 45 days of actual.
Oh, they only, okay, so that will be then for 10 and a half months.
10 and a half months, right?
Thank you, Your Honor.
All
Thank
right, Mr. Ham, any objection?
State objects, but the state will provide the victim's name. Her first name is spelled Irish, I-R-I-S-H. And her last name is Milton, M-I-L-T-O-N.
Thank you, Mr. Ham.
You're welcome.
All right, Mr. McLean, do you stipulate to the factual basis, venue and ID?
We do, Your Honor.
Mr. Holliday, if you decide, Mr. Holliday, if you decide to take this plea, I have to ask you some questions. Are you currently, have you recently consumed any medicine or alcohol?
No, ma'am.
Have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
If you decide to enter this plea, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get the opportunity to go back to court with your lawyer to confront your accuser, challenge the evidence brought against you, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
You understand that you're pleading guilty under the First Offender Act. If you do not comply with probation, or if you get arrested again, or if you violate the terms of your sentence, your first protection of the First Offender Act will be removed. Do you understand, sir?
Yes, ma'am.
With regards to one count of reckless conduct involving the illegal discharge of a firearm, how do you plead?
I plead guilty, ma'am.
Your sentence is going to be 1 year, 12 months to serve 90 days, credit for time served 22 days. You have additional time to serve at the jail, after which you'll be released, and then you must report to the Fulton County Probation on the first available weekday of Monday, Tuesday, or Thursday, immediately after your release. The Fulton County Probation Office is located at 132 Mitchell Street in downtown Atlanta. While you're on active probation, you will not possess and own any firearms. Any and all firearms that you own shall be surrendered to the police enforcement within 14 days of being released, and you must show the receipt to the probation officer that those weapons have been surrendered for destruction. While on probation, you will complete 240 hours of voluntary community service, and you must you must complete a minimum of 50 hours in the first month, and then I guess 40 hours per minimum of 40 hours per month thereafter. You're to complete 24 weeks of anger management classes, and you must enroll in those classes within 60 days of being released. You are to have no further contact with Irish Milton, and that applies even while you are at home. I'm not going to give you a stay away since that's your home, but please keep in mind that while you are in your home, if Miss Irish Milton is outside, you shall remain indoors. Do you understand? You
Yes,
shall
ma'am.
not communicate with her in any way, form, or manner, and even on social media, and even through the third party. If you are outside your home and you are leaving, you shall leave immediately, and you should not stall or falter anywhere in the front yard or the backyard if Miss Milton is outside. Do you understand?
Yes, ma'am.
You will report to probation every month for the remainder of the 10.5 months that you have, and you will pay your probation fees. Thank you.
Thank you, Your Honor.
Your Honor, I'll take a moment to explain more about the First Offender Act to him.
All right, and Miss Champion, please note that this is under the first offender provisions. All right, thank you, and let's move on to the next case, please.
Position 9 and 10, 3 South, Mr. Holmes.
Well, that's not good. Yeah.
Mr. McLean, you will have to hold off on that explanation. That's your
That's
client
fine.
as well. Okay.
That's fine. Yes, thank you.
Willie Holmes is case 20 CR 4882C, accused of battery family violence from July 31st, 2020, and he's got a bench warrant under 24 FTA 693. Mr. Holmes, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. McLean. Mr. McLean, I understand this is going to be a not guilty plea. Would that be correct?
Right, with the bond request.
All right. This will be, are you filing a waiver arraignment, or would you like me to arraign the case?
I'll be glad to file a written waiver, Your Honor.
All right. This will be a waiver of arraignment for both matters, and Mr. Holmes, your attorney is entering a not guilty plea. The cases will be further noticed for trial. Could you please tell me what's his current bond and why are we seeking a amendment?
Let's see, I can grab that from over here.
Mr. Ham, do you know
Your
what's
Honor,
his current bond?
His bond is, it looks like 2,000.
Okay. Is
On
that
the
on the bench warrant?
It's on the FTA itself, Your Honor. That's the only
Okay.
bond on the sheet.
And why has Mr. Holmes not appeared in court?
Your Honor, he says that now this took place in 2020, apparently, if anything took place. And I noticed this is an odd situation, Your Honor. He had 507 days of credit built up already, which exceeds the amount of possible punishment in terms of jail on this. So, of course, they were offering time served, I believe. But he called the clerk's office and was told to keep calling the clerk's office. At some point, there was a failure of communication. The case is from the summer of 2020, and I noticed that the previous attorney is listed on the case, so some preparation has been made. Mr. Holmes, would you tell the judge why the communications with the clerk failed or stopped?
He's on mute.
Yes, ma'am. I went to the courthouse several times to find out the date, but no one could tell me. So I went back again. No one still can tell me. So I just waited. I thought it would come in the mail. I checked my mail. I couldn't get no subpoena or nothing. I hadn't seen that. I'd have came, ma'am. No problem.
What address do you have listed with the clerk that you know of?
1993 Bent Creek Way, Southwest apartment H204, Atlanta, Georgia, zip code 30311.
Have you moved from there?
No, no, sir.
Has the clerk sent out the notice to that address?
I haven't seen anything.
Oh, hold on. That question was not for you.
Okay.
You wouldn't know what they mailed or not.
I'm sorry, Mr. McLean, who is that question directed to?
The clerk, I suppose. Did the clerk mail it out?
All right, I don't know who you're directing that question to. Can we move on
Yeah.
to any other reasons why you're seeking?
Right. He watched his mail and just never saw anything about it. So in good
Okay.
faith and sincerely, he was trying to keep up with it. But because of the situation of the credit that would have been built up had he been taken a guilty plea, we would ask the court to consider a signature bond. And of course, he's still at the same address and believes that his mail delivery is good.
All right,
I would suggest that he go back to checking with the clerk in person every 3 weeks.
Mr. Ham,
Yes, Your Honor.
was there an offer for time served in this case?
Yes, Your Honor. Just for clarification, when this case was originally brought, it was charged as a felony, and he was charged with aggravated assault with a deadly weapon, possession of a firearm by a convicted felon, and battery with substantial harm. The felony case, all of the felony counts dropped, and what remained is the misdemeanor case. So that's why he's been in custody longer than.
Understood. So just to clarify, he was booked into the Fulton County Jail on July 31st, 2020 for the felony charges involving a firearm. And at that time, he was also accused of this misdemeanor battery substantial physical harm. He was in custody for 507 days and released on December 19th, 2021. And then after which he received this bench warrant for failure to appear on July 7th, 2023. And he's been in custody now for 8 days. And the state's offer is to give him
Time served, Your Honor.
time served. All right.
Right.
And
And
he no longer wants to do that. The state is not opposed to a signature bond.
All right. Mr. McLean, your client is asking for a signature bond through the jail in order to come back to court to
Yes.
challenge this battery family violence. Would that be correct?
correct.
And in the event that the case goes to trial and the state carries its burden of proof that he should be found guilty of this particular offense of carrying the burden of beyond a reasonable doubt, the sentence was most likely be time served as well,
Correct.
possibly. Okay. All right. On Mr. Willie Holmes, on his battery family violence, on the bench warrant, the bond's going to be a $2,000 signature bond through the jail. He is to have no contact with the alleged victim. And he must maintain a current address with the courts at all times. No illegal drugs, no alcohol, no firearms. And Mr. Holmes, if Bellevue is your correct address, then you need to check on that mail, or you can consult with the public defender's office to make sure that you show up to court the next time for trial.
Yes, ma'am.
Thank you.
Okay.
Thank you.
Next case, please.
Position number 32, Taylor.
Good morning.
We have 2 Taylors on the calendar.
I'll
Position
see.
number 32, only one number 32 though.
Is this Jeremy Taylor?
That's Jeremy. Yes.
Okay, thank you. All right, Mr. Jeremy Taylor is case 24 CR 3348C, accused of theft by shoplifting, 2 counts of theft by shoplifting. The first one's from May 12th of 2024. The second one is from May 29, 2024. Mr. Taylor, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. This is Mr. Jeremy Taylor, who's entering a not guilty plea. And I believe Mr. McLean is going to be submitting a waiver of arraignment.
Yes, Your Honor.
Case is going to be further notice for trial. Thank you.
Thank you, Your Honor.
That's it, Mr. Taylor? Okay. Next case in courtroom 2.
We have, Mr. Freddie Tommy.
Give me the last name again, please.
Tommy.
Tommy.
Last name,
Tommy.
yeah, IE, number 34.
All right, thank you. Mr. Freddie Tommy. Case number is 21 CR 27998, accused of battery. Mr. Tommy, you've been advised of your right to remain silent, and your attorney is Mr. McLean. Mr. McLean, are we still proceeding with a non-negotiated plea?
Yes, Your Honor. I think the only reason for that, I believe, is the 30 divided by 2 is 15. So it's a matter of 4 extra jail days, and he wants to ask the court for time served on the jail portion of his sentence, even if that causes the court to increase anything else.
Let's see. Mr. Tommy, please raise your right hand for purposes of the plea. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? Please speak up.
Yes, ma'am.
All right, that I heard. Thank you. Ms. McKechnie, what's the state's recommendation?
But she's on mute.
Please unmute.
My apologies. The state's recommendation is 12 months probation, serve 30 days, credit for time served 11 days, balance probated, no further contact with Tamala McDonald-Dor, stay away from Grady Hospital except for medical necessity, and an MHET. The defendant is accused of punching Miss McDonald, who I might have just had a typo on her name, Miss Tamala McDonald, who is a nurse at Grady. He was receiving medical assistance for some unknown reasons and first appeared calm, and then his behavior quickly escalated and he began punching the victim. He does have 18 arrest cycles, including a 2010 battery conviction, a 2006 simple assault conviction, a 1985 simple battery and kidnapping and false imprisonment, and a 2021 arrest for battery family violence.
Thank you.
He
Yes,
does,
sir.
he does go to 10 Park Place for services. So I would think that the 10 Park Place, which is actually part of Grady, would not be part of the prohibition.
All right. I understand, but what other reasons should I reduce his jail time?
Your Honor, that the 4 extra jail days would not actually increase his understanding. He gets the point to behave correctly when he's seeking medical attention. Now, he switched over, by the way. He has switched over his medical care also to Piedmont, was it? I'm sorry? River Edge. I'm sorry, River Edge. So what I said about 10 Park Place that he used to go to, he might not need to even go there.
All right.
Oh, and he speaks rather softly, if I might. And Emory, River Edge and Emory. So
Okay.
there shouldn't be any further problems.
So he has a history with violence, and this is an attack on one of the members of our medical team, an unwarranted attack. This is not a situation arising from a dispute or a combat situation. I think 30 days is more than is an adequate time. I don't consider that enough, but I think is adequate. And so I'm not going to authorize a reduction.
Understood. He's going to stick with his plea, Your Honor. Yes.
And do you stipulate to the factual basis, venue, and ID?
For the purposes of the plea, we do.
Mr. Tommy, if you please sit up, and I need to be able to hear you. If I can't hear you, I'm going to have to reset the case to revisit this matter. Do you understand?
Yes, ma'am.
I think he's sitting up. He just needs,
He is sitting up, Your Honor.
he needs to lean forward. It's just-
Yes, perhaps lean forward. Thank you. Mr. Tommy, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
Do you understand why you are in jail today?
Yes, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
If you decide to plead guilty to this battery charge against Pamela McDonald, who was simply trying to render medical services, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not be able to go back to court with your lawyer. You will not confront your accuser, challenge the evidence brought against you, and be able to have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
No, ma'am.
No, listen carefully to her question. There won't be a trial, so you're giving up. By pleading guilty, you're convicting yourself, and you won't have a right to have witnesses on the stand that your lawyer would cross-examine. You could remain silent or testify as you choose. Beyond reasonable doubt would be the proof standard. Free lawyer if you can't afford one, things like that. The 7 trial rights. So do you understand you're giving them up?
Yes.
Okay.
Mr. Tommy, are you prepared to give up your constitutional right to a trial?
Yes.
How do you plead to 1 count of battery?
Guilty.
Speak up.
Guilty.
Your sentence is going to be 12 months to serve 30 days, credit for time served 11 days. You will have to serve the additional 4 days before you are released, and then you must report to probation. The probation office is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you must go to your medical provider either at River Edge or at what was the other one?
Emory.
Emory, okay? And while there, you are to undergo a MH evaluation, a mental health evaluation. Do you understand?
Yes, ma'am.
And you must submit yourself to any treatment. There cannot be any violence when you deal with the staff of the medical facility. Do you understand?
Yes, ma'am.
That concludes your sentence. Oh, and to stay away from Grady Hospital unless you are seeking emergency treatment or if you have an appointment to see a medical provider. Thank you.
Thank you, Your Honor. Like this.
Next is position number 11 and 12, Mr. Hudgens.
Your probation, that's fine. Once you do the mental evaluation, there's no guarantee of it. No. Go to the second one. We can do
This is State versus Sean Hodges.
No. Oh, Your Honor, I'm sorry to interrupt. He has confusion about one point. Could that be non-reporting once he shows the mental evaluation that would indicate?
No, no. Not for this case. He has to report every month.
Okay. There is no fine. The fees are $49 a month. Okay. You know, I think I need to speak with him a little bit further. I'll go in the back. A lot. That's not enough. Come on, Mr. Thomas.
Excuse me, Your Honor. Good morning. This is
Good morning,
Adriana
Ms.
Chancy.
Yes.
And I wasn't sure if I was needed at your session or at CIT this morning.
Okay.
Is this,
Let me clarify.
Thank you.
Courtroom 2, do we have any cases on the calendar? If Ms. Vigiletti and Mr. McLean can let us know that require a Spanish interpreter?
I don't, Your Honor.
Mr. McLean,
McLean. Right.
do you need a Spanish interpreter?
You need a Spanish interpreter. No, Your Honor.
All right.
Thank
I don't
you,
believe
Your
so. Thank you, Ms. Chansey.
You're
Maybe
welcome.
security. Thank you.
Thank you.
All right. Is Sean Hudgens at 3 South? Okay,
Yes. He's
thank you, thank you.
claim. You tell
And
McLean.
yes, Mr. McLean, unfortunately, I'll need you back in the hot seat. Thank you, sir. This is State versus Sean Hudgens, accused of criminal trespass from February 8th, 2024, in case 24 CR 688E. Mr. Hudgens has also got a bench warrant from March 18th, 2024. I understand this is going to be a negotiated plea. Mr. Hudgens, you have a right to remain silent. Anything you say about the facts of the case, your statements can and will be used against you. You have a right to an attorney, and representing you presently is Mr. Michael McLean. For purposes of the plea, may I place you under oath? And please unmute. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Mr. Ham, what's the recommendation for Mr. Hudgens?
Yes, Your Honor. The recommendation is 12 months to serve 26 days, credit for the time served 13 days, the balance to be served on probation. For Mr. Hutchins to complete 40 hours of community service and to stay away from 3129 Candlewood Drive Southwest in East Point, Georgia. He's also to have no further.
3129 where?
3129 Candlewood Drive.
I'm sorry, sir, your audio is fading in and out.
Okay. Candlewood Drive, Candlewood Drive
Got it.
South in East Point, to have no further contact with Angelo Gamble, Angelo Gamble, and to take 8 weeks of anger management classes. As it relates to position number 12, the state will move to null prostat.
Thank you, Mr. Ham.
You're welcome.
Mr. McLean, does your client accept these terms, and do you stipulate to the factual basis, venue, and ID?
He does. For the purposes of the plea, we do.
Mr. Hudgens, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
Is anyone forcing you to take this plea today?
No, ma'am.
If you decide to plead guilty to this criminal trespass charge, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not have the opportunity of going back to court to challenge this particular case in a court of law. You won't be able to confront your accuser, present any arguments, defenses, and mitigating factors, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of criminal trespass?
Guilty.
Your sentence is 12 months to serve 26 days, credit for time served 13 days. The remainder of the time will be served on probation. You will report to probation on Monday, this coming Monday. That would be the 17th of June. And the probation office is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will complete 40 hours of community service, and you must do that by the completion of 5 hours per month. 5 hours minimum every month thereafter. You have to stay away from 3129 Candlewood Drive in East Point and have no contact with Angelo Gamble. You have to stay 200 yards away from him and not communicate with this person in any way, form, or manner. You're also to complete 8 anger management classes, and you're to enroll in those classes within 30 days of being released.
Yes, ma'am.
If you fail to comply with these requirements, probation is authorized to revoke by issuing a warrant for your arrest, and you'll be back in jail to serve out the rest of the year. Do you understand?
Yes, ma'am.
Any questions?
No, ma'am.
That ends your plea, and the bench warrant is null pros. Next case, please.
Your Honor, can we go to the add-on, and it's gonna be Mr. Denoris Ville. And that's add-on number 6.
All right. Is that gentleman in courtroom 2?
That is correct.
Thank you. This is State versus Denoris Ville, 24 CR 3298F. Mr. Ville has got a misdemeanor case stemming from a traffic incident. The charges are as follows: driving while license suspended or revoked, driving under the influence of alcohol less safe, 2 counts of striking an unattended vehicle, and misdemeanor possession of marijuana. This stems from a May 27, 2024 incident. And Ms. Vigiletti, how are we proceeding in this matter?
Your Honor, I'd like to make a bond request this morning.
All right.
A bit of
Has this case been arraigned?
I'm happy to file a waiver.
All right. I don't know if it's been arraigned, but if it's not, then we'll accept your waiver of arraignment.
Yeah, well, that's it.
And this is going to be further notice for trial. Mr. Ville, your attorney is entering a not guilty plea on your behalf, and your case is going to be further notice for trial. Okay, and I'm so sorry, give me a moment to, this is on the add-on calendar. All right, you may proceed, Ms. Vigiletti.
Thank you, Judge. This is a complicated situation. It's a pretty complicated case. There are 4 charges here that could each result in their own separate license suspensions. And unfortunately, all I have in terms of discovery is the narrative of the warrants. I don't have any evidence of a field test or a blood test. I don't have any witness contact information, no body cam footage. I don't know if or when or why his license was suspended previously. And because it's so consequential, I've actually been told by my supervisors, I can't advise him regarding a plea because we just don't have enough information to do so competently. In the meantime, so, of course, we do need discovery on this case. In the meantime, Mr. Ville tells me he has 5 children that live with him and his partner. She's a stay-at-home mom. He is the breadwinner. He's been in for almost 2 weeks. And being in jail is simply burying their family. I mean, they're at risk of losing their home if he's in much longer. He was working at a place called Hydrospec. It's a erosion company. He does work that fortifies buildings to, keep the ground safe underneath them. And he is the only breadwinner for these children. And so I'm asking this morning, Your Honor, if you would consider a bond reduction and ideally a signature bond. It's part of the system that sometimes we don't have all the information we need to properly address a case. But, his kids and his partner shouldn't suffer, shouldn't become homeless because of that. He's happy to comply with any bond conditions. Of course, not driving is going to be an important part of it. Driving under the influence, of course, is a very serious allegation. He's really just trying to get to work to keep the stability that he has underneath him. They have a stable house. They have, a stable phone. He has every incentive to show up for court because this is so consequential. I do believe he has 1 prior failure to appear on his record in the process of moving. That's not his situation right now. The reason he wants to get out of jail while we get this further information is because he wants to get back to work and keep this kind of stable life he's built with his partner.
So my pretrial officer, please, I'm so sorry.
That's okay. Good morning, Your Honor.
Good morning. And Ms. Tyson, I understand that he's got a Clayton County hold. Could you refresh my memory again? What was that charge for?
Let's see.
Yeah, it's a traffic charge, I believe, Your Honor.
I understand. Is it for simply having expired registration or something more serious?
That I'm not sure.
He's running the stop sign.
I don't show anything on the GC
I have a hold.
indicating that.
Do you see a hold? It's on the jailing screen.
I don't have, so on the GCIC, the warrant for the hold is not popping up.
Okay.
Yes,
Ms.
I don't have
McCarthy,
the warrant.
do you have thank you, Ms. Tyson. Ms. McCarthy, do you have a response?
The state feels that the current bond is appropriate. He did hit 2 parked vehicles. And he did have alcohol on his breath and was unsteady while standing according to the warrant. So the state believes that the current bond is appropriate and we would be opposed to it becoming a signature bond. I do also see that he has 2023 arrest for driving while his license was suspended or revoked. So this is not, something new.
All right. Ms. Vigiletti, I do appreciate the brevity of or the lack of information that you have for this particular charges. But I'm reading the warrants as well, and they are especially egregious. This is not only an alleged collision with one vehicle, but then it led to a chase where the defendant allegedly struck another vehicle and then ended up in the hospital. So I'm not certain what's transpiring in terms of what kind of evidence do you need in order to make a recommendation to your client. But presently, I have probable cause for these charges, one of them being a driving while license suspended or revoked. And according to the jailing screen, he's got another traffic matter to address in Clayton County. I understand his concern for his family, but clearly he has less concern for the rules of the road and the law when operating a vehicle. So the bond is going to remain the same.
Your Honor, I apologize. I did find the hold on the GCIC. It's for misdemeanor probation violation. They just didn't list the underlying charge for that.
Okay. So if he does bond out, Clayton County will have to come pick him up for this misdemeanor probation matter. Thank you.
Understood, Judge. Thank you.
Probations 2 and 3, Mitchell.
This would be at 3 South. Would that be correct?
That's correct, Your Honor.
All right. I do apologize. I'm just it's taking a little time to pull up that calendar.
Mitchell?
This is, and who represents,
Your Honor, I do not have a calendar that's got the name Mitchell on it for probation.
it's Dontavius Mitchell.
This was the one from the Tuesday calendar.
Oh, that's correct. Okay.
Update calendar was sent out. I don't know if everybody received it or not. Mr. Jordan sent it out.
I did have it. I did have it. Yes. Okay. So this is Dontavius Mitchell, case number 23 CR 4527J, in which Mr. Mitchell was convicted of criminal trespass. He's got a probation violation matter, 24 PV 952. Mr. Mitchell, you have a right to remain silent. Anything you say in court, your statements can and will be used against you. You have a right to an attorney, and your current counsel is Mr. Michael McLean. Ms. Allen, if you don't mind, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. And what is the reason for the revocation and the state's recommendation?
Your Honor, the defendant was required to complete 40 hours of community service. He has failed to provide our office with the community service completion letter. He has been in custody since June 5th, 2024. It is 57 days remaining on his case. At this time, probation recommends that his case be time served.
Mr. McLean? I'm sorry, you're muted.
I would think he would have no objection to that, Your Honor. I think he would appreciate that very much.
Please unmute 3 South. 3 South, please unmute. Mr. Mitchell, you have a probation violation for your conviction of criminal trespass for failure to complete 40 hours of community service. The recommendation is that the probation be commuted to time served and that your case be closed. But this will be recorded as a probation violation. Are you in agreement?
Yes.
Please speak up.
Yes.
All right. This will be recorded as a violation and the case is commuted to time served. Thank you. Do we have a Xavier Henderson also?
Yes, Your Honor.
We do. I wondered if Ms. Allen could chat the recommendation on Mr. Henderson for me to make sure. I had seen the previous email, but I think maybe it's gone into, sometimes it goes from focus to other when I'm looking for the email again.
Understood. I
yeah.
mean, I'll let her email that, but right now let's go ahead and put it on the record what it is.
Sure.
This is case 22 CR 64318, Xavier Henderson, who was convicted of disorderly conduct. Mr. Henderson, you've been advised of your right to remain silent. Your attorney is Mr. McLean. And this is a probation revocation matter with regards to your case. Ms. Allen, you've already been sworn. What's the state's recommendation? And well, first of all, why is a revocation being sought?
Your Honor, it looks like the defendant was required to do a 44 hours, not 40, but 4 hours of anger management classes, no contact with the victim in the case. This defendant has failed to provide documentation of the anger management course completed. He's failed to report to our office. It is 218 days remaining on his case. At this time, probation does recommend for him to be allowed to continue on probation to complete that course.
All right, thank you.
Second chance.
Mr. McLean, you may mute your screen if you want to confer with your client.
Oh, that's fine, Your Honor. I appreciate that. He would like to ask to continue on probation.
But he understands that he needs to do the 4 anger management classes, and he'll be required to report twice a month until the anger management classes are completed. Not just once a month, it will be twice a month.
Understood, Your Honor, the increased rate.
All right, Mr. Henderson, are you in agreement with this arrangement?
Yes, ma'am.
This will be recorded as a probation violation. And Mr. Henderson, you will report to probation on Monday, which will be the 17th of June, and you must report before 3 p.m.
Yes, ma'am.
You will report twice a month, and you will you will enroll in an anger management class within 30 days of being released. And you'll be required to complete 4 anger management classes. Each management class is about 1 hour, so you'll need to do 4. That would take you up to 4 weeks. So you report twice a month. You report the status of your enrollment and attendance of those classes. And once you have completed the 4 anger management classes and you are up to date with your probation fees and surcharges, then probation will be non-reporting. Thank you.
Add on position number 5, Mr. Robertson.
Your Honor, that concludes my business.
Thank you, Ms. Allen. Yes, ma'am.
All right, thank you.
Give me a moment, please.
Add on position number 5, Mr. Robertson.
Yes, yes, ma'am. Sorry, just trying to get to that case. Thank you. And that was add-on position number 5. Is that your client, Ms. Vigiletti?
No, Your Honor, this is another conflict case. He was reset from Tuesday because he needed a conflict attorney assigned.
All right. And Ms. Champion, has a conflict attorney been notified to speak to Mr. Champion?
Let me check, Your Honor. I don't have any notations on this calendar. Let me check.
And this is add-on number 5. Is this Ronald Robertson? Is this Ronald Robertson? 3 South. What's the name?
Yes, that's the name I gave you.
All right, the case was reset from Tuesday in order to appoint conflict counsel to represent him. And Ms. Vigiletti, you are fairly certain that this case requires conflict?
Yes, Your Honor, I did send an email about it last week as well. Let me pull up the reason why here.
All right.
Okay, Your Honor, we're trying to get Ms. McLeod to see if she can log back on for us.
Okay. All right, 3 South, we are going to see if Miss Maureen McLeod will be able to confer with him.
And Your Honor, I'll just confirm our office did represent the victim, alleged victim in this case in a separate matter, so.
I see. Okay, thank you. Courtroom 2, do we have another case to address?
This is going to be position 22 and 23, Mr.
Thank you.
Rivers, Michael Rivers.
All right. This is State versus Michael Rivers. Position 22 is case 23 CR 2935E. Mr. Rivers is accused of criminal trespass from May 12th, 2023. His second case is a bench warrant 24 FTA 694 for failure to appear on June 5th, 2023. Mr. Rivers, you have been advised of your right to remain silent, and your attorney is Ms. Vigiletti. I understand this is going to be a negotiated plea. Would that be correct?
Yes.
Mr. Rivers, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Ms. Mokeki, what is the recommendation?
The state's recommendation is 12 months probation, served 20 days, credit for time served 10 days. That balance is going to be suspended with the condition of stay away from the Kroger located at 1700 Monroe Drive, Northeast, Atlanta.
Ms. Vigiletti, do you stipulate to the factual basis, venue, and ID?
We do.
Mr. Rivers, have you consumed any medicine or alcohol?
No.
Have you understood what's going on in your case?
Yes.
Are you satisfied with your attorney?
Yes.
If you decide to plead guilty to this charge, you would have to give up your right to a trial in front of a judge or a jury. You will not get a chance to confront your accuser, challenge the evidence brought against you, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to one count of criminal trespass at the Kroger supermarket?
Guilty.
Your sentence is 12 months to serve 20 days, credit for time served 10 days. Balance is suspended. Once you're released, please remember that you are not allowed back at the Kroger at 1700 Monroe Drive. If you return to that location, you will be arrested again. Thank you. The bench warrant is null pros. Next
Next, we
case.
have position 24 and 25, Mr. David Roger. Thank you.
Ms. Vigiletti, are we ready to proceed with a plea?
Yes, Your Honor, this is going to be a non-negotiated plea.
All right. David M. Rogers accused of willful obstruction of an officer and theft by taking under accusation 22 CR 3136F from February 1st, 2021. Mr. Roger also has a bench warrant 24 FTA 689 from June 3rd, 2024. Mr. Roger, you've been advised of your right to remain silent. Your attorney is Ms. Vigiletti. This is going to be a non-negotiated plea hearing. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Ma'am.
We're going to hear from the prosecutor first, and then I'll hear the recommendation from your attorney. I will let you know which option I will impose, keeping in mind that I can reject either plea offer and have this case set for trial. Ms. Mokeki?
Yes, Your Honor. The defendant is accused of taking two LGE 43-inch TVs valued at $243 from the property of Mr. Varick Mills. The victim showed police a recording where the defendant admitted to taking the TVs because he needed money. When the officers tried to place the defendant under arrest, he began resisting, and the officers had to use an armbar technique to detain the defendant. Our office did have a chance to speak with the victim, who stated that he is in agreement with the state's plea offer, and he also will be emailing a receipt for restitution. I would like to bring to the court's attention that the defendant has 38 arrest cycles, including theft by taking convictions from 2002, 2007, 2 from 2011, 2 from 2014, and theft by taking arrests from 1999 and 2005. The state's recommendation for count 1, the willful obstruction, is 12 months probation, a $300 fine to run concurrent with count 2. The state's recommendation for count 2 is 12 months probation, served 38 days, credit for time served 19 days, balance probated, an anti-theft course, 40 hours community service, restitution to the victim open for 30 days, no further contacts with the victim, Mr. Varick Mills, and stay away from the incident location, which I have as 3585 Roosevelt Highway, College Park.
Why would we need to keep the issue of restitution open for 30 days if you have a value of $243?
The victim is sending us a receipt for the restitution, but I guess we wouldn't need to hold it open for 30 days.
If nothing is done within 30 days, then the restitution will be 0.
So I will remove the open for 30 days from my recommendation.
All right. The restitution is 243 days. Ms. Vigiletti, what's the defense's position?
Your Honor, if you could just give me one moment. Your Honor, Mr. Roger was concerned about not knowing what the amount of the restitution was, and that was why we were going to have a non-negotiated plea this morning to discuss the uncertain nature of that statement. But with restitution being solid at $243, I think we're actually prepared to enter a negotiated plea this morning.
All right.
And if you could give me 1 second, I just want to make sure that's not $243 for each TV.
That's what I was going to ask you.
Just take a look at that warrant one more time. So the warrant just says 2 LGE TVs valued at $243. I am not sure if that's each. I would anticipate that it would be each is worth $243, but the warrant doesn't specifically say. It just says 2 TVs valued at $243.
Restitution's at $243. Would your client like to proceed?
Yes, Your Honor.
And do you stipulate to the factual basis, venue, and ID?
We do.
Mr. Roger, have you consumed any medicine or alcohol?
No, ma'am.
You need to speak up, sir.
No, ma'am.
And have you understood the proceedings in your case?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And is anyone forcing you to enter this plea today?
No, ma'am.
If you decide to plead guilty to this theft by taking, this will be another conviction entered on your significant criminal history record. Do you understand that?
Ma'am.
And you also understand that if you plead guilty, you will not get a chance to a trial before a judge or a jury. You will not have the assistance of counsel to confront your accuser, challenge the evidence that's presented to you in trial, present your own arguments and defenses, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Ma'am.
Repeat.
Yes, ma'am.
How do you plead to 1 count of theft by taking from February 1st, 2021?
Guilty.
Your sentence is going to be 12, and how do you plead to the willful obstruction of an officer?
Guilty.
Your sentence for the theft by taking is 12 months to serve 38 days, credit for time served 19 days, balance probated. You will report to the probation office on Monday, June 17th, before 3 p.m. The probation office is located at 132 Mitchell Street in downtown Atlanta. While you are on probation, you will complete an anti-theft class, and you must enroll in that class within 30 days of being released. You're also to do 40 hours of voluntary community service, and you must do a minimum of 5 hours per month and a minimum of 5 hours every month thereafter until the 40 hours of community service are completed. You will pay a full restitution of $243, and you must make a minimum payment of $25 per month towards probation, and probation will direct those funds to the victim, Barrett Mills. While you're on probation, you will report every month. You will pay your probation fees every month. You will also stay away from 3585 Roosevelt Highway and have no contact with Barrett Mills. With regards to the obstruction charge, that will be 12 months concurrent to count 2, and there will be an additional $300 fine. You must make a minimum payment of $50 towards that fine every month thereafter. Understood?
Yes, ma'am.
And Your Honor, if I may just, Mr. Roger will be released to a hold, so he's not able to report on Monday. He will be able to report after his hold is resolved.
Where is that hold?
In DeKalb.
All right. And is it a felony or misdemeanor hold?
I believe it's a misdemeanor, Your Honor.
All right. Then he will report to Fulton County Probation on the first available business day immediately after his release, which will be a Monday, a Tuesday, or a Thursday before 3 p.m.
And if I may, Your Honor, I'm sorry, I should have asked this earlier. Mr. Roger, because he has been in custody for a while, has, is going to be on the job hunt when he leaves, his final custody. And
I will waive probation fees for 3 months.
Thank you, Your Honor.
All right. Thank you. Medical, who do we have?
This is add-on position 1 and 2, Mr. Cole.
Oh dear, audio is not good. Ms. Vigiletti, is this another case that requires a,
Sit down.
Is this Marco Cope, Your Honor?
Yeah.
This is Mr. McLean's client. I believe they're ready.
okay,
Mike. You have to talk to This is Marco Cope add-on 1. Okay, Mr. Cope. We had him 2 days ago, Your Honor, and at that time, he said he did not understand. Yet, when I spoke with him, he did want to take the plea. So maybe he understands today, and hopefully we can get through the plea. Otherwise, we'll have to go to Plan B.
okay, please hold. This was Mr. Pope, correct?
Yes, Your Honor, Mr. COPE. It's on the add-on.
Oh, no, I'm just trying to get the notes from,
It was position 12 and 13 on the June.
was he position 12 on the,
It's position 12 and 13 on the June 11th.
thank you. Thank you very much. Okay. Okay. All right, so we are readdressing Mr. Marcus Pope from Tuesday. 24 CR 1364G, in which he's accused of criminal trespass at Georgia Tech campus. And his second case is 24 CR 3035G, in which he's accused of simple battery, theft by shoplifting, a simple battery against an officer, and violation of rules regarding a pedestrian and roadway. Mr. Pope, Mr. Cope, please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and Mr. Michael McLean is representing you. Okay, so from what I gather, Mr. Cope, is required to serve 56 days with a credit of time of 28 days. Or was that 60? So was that the problem, Mr. Ham?
So yes, on Tuesday, we reduced it to 58 days because there was an issue about whether he needed to serve an additional 2 days. But now that he has actually served the additional 2 days in custody, it will remain what's written on the original offer, which would be serve 60 days, credit for time served 30 days, balance to be served on probation.
All right. Mr. McLean, if he has no other holds at the jail, it looks like if he decides to move forward with this plea, he would be released within 24 hours, but he needs to report to probation on Monday.
And I believe the pedestrian roadway was going to merge or be dropped, if I remember from the other day.
Everything was time served with regards to pedestrian roadway. Count 3, simple battery against an officer was concurrent to the theft by shoplifting. And the simple battery was concurrent to the theft by shoplifting.
I may be thinking of somebody else's pedestrian and roadway count. If that was simply concurrent like the others, then it doesn't cost him any extra time, true. I was just thinking that one might have been dropped. I'm not sure.
All right. So, Mr. Cope, for purposes of the plea, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do, yeah. Yes, ma'am.
All right. Mr. Ham, could you, let's go ahead. So for the criminal trespass, it was going to be basically 3 days time served, balance suspended, and stay away from Georgia Tech campus. Would that be correct?
That's correct, Your Honor.
All right. And for Mr. Cope's second case on the theft by shoplifting, the sentence was 12 months to serve 56 days, credit for time served 28 days. Balance probated to stay away from the High Society Smoke Shop, stay away from 694 Morosco Drive, complete an anti-theft class and 40 hours community service. And on the simple batteries concurrent to count 2 with no contact with Angel Boyk, excuse me. And count 3 and count 4 are both, count 3 on the simple battery against an officer is concurrent to count 2. And on the pedestrian and roadway, it is time served, 21 days in jail.
That's right. Just a slight adjustment, being that he's actually now served additional time in jail. It will be 60 days, credit for time served 30 days instead of 58.
Serve 60 days, credit for time served 30 days. But in any event, he'll be released within 24 hours and he must report to probation on Monday, June 17. Mr. McLean, is that what you discussed with Mr. Cope?
Yes, Your Honor.
And Mr. Cope is in agreement with these terms?
I had thought so, Your Honor. At one point, Your Honor asked him if he understood everything, and he said, "I don't," and that's when we terminated, put to today.
All right, please unmute medical. Mr. Cope, you have 2 cases. One is for trespass at Georgia, and if you decide to plead guilty, that would be time served, and that case would be closed. On the battery and the theft by shoplifting charges, you'll have to be on probation, where you'll be required to stay away from certain locations, do an anti-theft class, and 40 hours of community service.
Yes, ma'am. I
Are these
understand.
the terms that you understood?
Yes, ma'am, I understand.
All right. Mr. McLean, do you stipulate to the factual basis, venue, and ID?
We do.
All right. Mr. Cope, have you consumed any medicine or alcohol?
No, ma'am.
Have you now understood what's going on in both your cases?
Absolutely, yes, ma'am.
Are you satisfied with your attorney?
Absolutely.
If you decide to plead guilty to these 2 cases, you would have to give up your constitutional right to go back to court and have a trial in front of a judge or a jury. You will not get the opportunity to confront your accusers, to challenge the evidence brought against you, to be able to present any arguments and defenses and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Absolutely, yes, ma'am.
How do you plead to one count of criminal trespass at Georgia Tech?
Guilty, ma'am.
Your sentence is 21 days. You've completed that time. Once you are, you are to stay away from all Georgia Tech University property. If you return to any of their properties, you will be arrested and brought back to jail. Understood?
Absolutely. Yes, ma'am.
For the second case, how do you plead? Simple battery, theft by shoplifting, simple battery against an officer, and violation of rules of a pedestrian and roadway.
Guilty, ma'am.
On the theft by shoplifting, count 2, the sentence is 12 months to serve 60 days, credit for time served 30 days. Your jail time is concluded. You'll be released within 24 hours, but you must report to the probation office on Monday, June 17, before 3 p.m. While you're on probation, you will stay away from the High Society Smoke Shop at 694 Morosco Drive. You will complete an anti-theft course, and that must be enrolled within 30 days of being released. And you will complete 40 hours of community service at any nonprofit agency that's not a church and not a school. Count 1 for simple battery. Your sentence is 12 months, concurrent with count 2, and no contact with Angel Boyd. Count 3 is 12 on the simple battery against an officer, is 12 months concurrent with count 2, and pedestrian and roadway is time served, 30 days in jail. That concludes your sentence.
Yes, ma'am.
Courtroom 2, who do we have next?
Next, Your Honor, we're gonna go to position 28 and 29. That's gonna be Mr. Terrence Simmons.
This is going to be State versus Terrence Simmons, case 24 CR 1692D, accused of criminal trespass. And Mr. Simmons also has a bench warrant from 24 FTA 691. Mr. Simmons, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. Mr. Simmons, for purposes of the plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Mokeke, what's the offer?
I believe he also has an add-on for 2 theft by takings, 24 CR 003450D.
Let me make sure of that. I don't have that.
Your Honor, I believe it was Ms. Fox that added it on in the body of her recommendation. So it wouldn't be on the add-on calendar. If you look at the calendar that has recommendations, that case was added.
I don't have that file with me, Your Honor.
Let me see. Ms. Champion, so do you need the physical file in order to address that?
I will have to have someone print me out a sentence sheet. I don't have the sentence sheet or anything to write it up.
All right.
I'll get that together for you, April. What's the case number again, Judge?
I don't have hang on, I'm trying to find Ms. Falk's recommendations.
Okay, I can give the case number if you would like, Your Honor.
What is it, please?
24 CR 003450D.
Okay.
All right. So, Ms. Champion, just make a note that we are addressing his second case, 24 CR 3450D, in which he's got 2 counts of theft by taking. This apparently appears to address the Whitley Hotel at 3434 Peachtree Road. All right. And so these are the open cases that we are addressing with regards to Terrence Simmons, the criminal trespass, the bench warrant, and the 2 counts of theft by taking. Are these the matters that we are addressing, Ms. Vigiletti?
Yes, Your Honor, we were prepared to address everything today.
All right. May I place him under oath for purposes? Oh, I already have. Thank you. Okay, Ms. Mokeke, go ahead.
Yes. For the criminal trespass, the state's recommendation is 12 months probation, served 30 days, credit for time served 15 days, balance suspended, stay away from East Point City Garage, located at 3120 Bayard Street in East Point, Georgia. For the add-ons, the 2 theft by takings, count 1 is going to be 12 months probation, served 22 days, credit for time served 11 days, balance probated, stay away from the Whitley Hotel, no further contact with the victims Edcia Rodriguez and Stephanie Russo, anti-theft course, 20 hours community service, and an MHET. For count 2, that is going to be 12 months probation to run concurrent with count 1.
All right. Ms. Vigiletti, sorry.
FTA will be no frost.
Okay. And Ms. Vigiletti, do you stipulate to the factual basis, venue, and ID?
We do, Your Honor. I did also want to ask, Your Honor, Mr. Simmons has been homeless for quite some time. He does have an identification, so we are working on getting him, some housing. It is probably going to be a shelter. He is employable and job seeking, but doesn't have a job. And I was wondering if he'd be willing to waive his probation fees as he sort of gets his feet under him when he leaves the jail today.
2 months waiver.
Thank you.
All right, and do you stipulate, Ms. Vigiletti, to the factual basis, venue, and ID for both cases?
We do.
All right. Mr. Simmons, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's been going on in both your cases?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And if you decide to plead guilty to the charges in both these cases, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get the chance to go back to court to be able to confront your accuser, challenge the evidence brought against you, present your defenses and arguments through your counsel, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to criminal trespass from April 4th, 2024 at the East Point City Garage?
Guilty.
Your sentence is 12 months to serve 30 days, credit for time served 15 days, balance suspended. Do not return to that garage. You're to stay 200 yards away from 3120 Bayard Street in East Point, Georgia. With respect to case 24 CR 3450D, how do you plead to the 2 counts of theft by taking?
Guilty.
On count 1, the sentence is going to be 12 months to serve 22 days, credit for time served 11 days. The remainder of the time will be on probation. You will report to probation on Monday, June 17th before 3 p.m. And that's at 132 Mitchell Street in downtown Atlanta. While on probation, you will stay away from the Whitley Hotel at 3434 Peachtree Road. And that means a distance of 200 yards. So you'll have to stay quite far away from that intersection. You are to have no contact with Edcia Rodriguez and Stephanie Russo. Within 30 days of being on probation, you will enroll in an anti-theft class and you will complete that class. You will also complete 20 hours of community service with a minimum of 5 hours of community service hours being done every month. You will also enroll in a mental health evaluation and submit yourself to any treatment that's required, and this must be done within 2 weeks of being released. On count 2 will be concurrent with count 1. That concludes the sentence. The bench warrant is null crossed.
Thank you, Your Honor.
Jail court iPhone, who do we have, please? Oh,
Position 35, Townsend.
all right.
Mike.
This is State versus Anthony Townsend, case 24 CR 3351D, accused of battery and willful obstruction of an officer. Mr. Townsend, you have a right to remain silent. Anything you say about your case, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Michael McLean. Mr. Townsend, if you please raise your right hand. For purposes of the plea, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right. Ms. Mukeke, what's the recommendation?
Yes, Your Honor. Mr. Townsend also has another add-on case that was added onto the recommendation, and that is for a criminal trespass.
Let me get to that. Position. All right, and Ms. Champion, would you happen to have the disposition paperwork for this case? 24 CR 3084D.
No, ma'am, I do not.
All right. Ms. Lewis, if you could be nice, please, pretty please print the paperwork for Ms. Champion. The case number.
Can you give me case number again, Judge?
Sure. 24 CR 003-084 D as in Denmark.
Okay.
All right, so Mr. Townsend, we are addressing both these cases involving you. Ms. Mukeke?
Yes, Your Honor. For the battery and willful obstruction, the state's recommendation is as follows. For count 1, that is 12 months probation, serve 120 days, credit for time served 16 days, balance probated, no contact with Monique Knox, stay away from 2717 Sylvan Road, Atlanta, and MHET, and 8 weeks anger management. For count 2, that is 12 months probation to run concurrent with count 1 and a $300 fine. In regards to the add-on, the state's recommendation is 12 months probation, serve 2 days, credit for time served 1 day, balance suspended with the condition of staying away from the Chevron located at 890 Cleveland Avenue in East Point.
Ms. Vigiletti, excuse me, Mr. McLean, does your client stipulate to the factual basis, venue, and ID?
Yes, Your Honor, in both cases. We discussed both cases yesterday.
All right. Mr. Townsend, you understand that you are pleading guilty to 2 separate cases. Is that your understanding?
Yes.
Have you consumed medicine or alcohol recently?
No.
Have you understood what's going on in both these cases?
Yes.
Are you satisfied with your legal services?
Yes.
Has it been explained to you that if you plead guilty to these 2 cases, you will not get a chance to a trial before a judge or a jury in the future? You will not go back to court with your lawyer to be able to confront your accusers, challenge the evidence brought against you, present your own arguments and defenses if you choose to do so, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to battery and willful obstruction of a law enforcement officer in case 24 CR 3351D?
Guilty.
Your sentence. And how do you plead to criminal trespass in 24 CR 3084D?
Guilty.
On the battery charge, your sentence is 12 months to serve 120 days, credit for time served 16 days. You have 41 more days to serve at the Fulton County Jail in order to serve out the sentence for battery. Once you have completed the 41 days, you will then report to probation at 132 Mitchell Street on the first business day before 3 p.m. While you're on probation, you will complete a mental health evaluation within 14 days of being released, and you will enroll in an 8-week anger management program within 30 days of being released. At all times, you are to have no contact with Monique Knox and to stay away from the Larry's Quick Stop at 2717 Sylvan Road in Atlanta, Georgia. For the willful obstruction of an officer, your sentence is 12 months probation concurrent to count 1 with an additional of $300 fine. You will make a minimum payment of $50 per month towards your fine and a minimum payment of $50 every month thereafter. On the second case, the criminal trespass, your sentence is 12 months to serve 2 days, credit for time served 1 day, balance suspended. You are to stay away from the Chevron gas station at 890 Cleveland Avenue in East Point, Georgia. If you return to that location, you'll be arrested again. Do you understand, sir?
Yes.
Mr. McLean, any questions?
Yes, Your Honor, I think the calculation, with the 120 divided by half be 60 minus 16, it's gonna be 44. So
Okay,
I had warned him that 44 was what he was likely facing before release.
all right. I don't divide the initial 120, but if you want to do it that way, that's fine. 44 days then.
Well, I'm not trying to get him 3 extra days. That's just the way the math is.
Okay,
I'd rather have fewer.
all right. We're concluded with Mr. Townsend. Thank you.
Position number 2, Bolden.
This is Brandon Bolden, accused of criminal trespass in case 24 CR 3370A from May 29, 2024. Mr. Bolden, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Miss Vigiletti. Miss Vigiletti, this is going to be a plea?
Yes, Your Honor.
All right. Mr. Bolden, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Mr. Hand, what's the recommendation for Mr. Bolden?
Yes, Your Honor, I just want to bring to the court's attention before we begin that there are 2 additional criminal trespass cases that were added on, and I'm not sure if
Oh
case
dear.
manager-
Miss Champion and Miss Lewis are not going to be happy with you guys. I'm just going to let you know that right now. Okay, let me see. My goodness. Miss Champion, I know you're fuming right now, but Miss Lewis, would you be able to?
Yeah, I've been helping her. What's the case number?
First
So the
one
first
is 24 CR 002-122A, criminal trespass. Second case is 24 CR 003-024A, criminal trespass.
All right.
So, Ms. Vigilante, we are addressing 3 cases against Mr. Bolden, in which each charge is criminal trespass.
Yes, Your Honor, and I did speak to Mr. Bolden about all 3 cases, and we also discussed a plan for no future incidents. So I believe we're ready to proceed.
Let me see. Do they all involve the Chevron gas station at Washington Road?
They do, Your Honor. And I'll just say upfront, Mr. Bolden has joined the Grady Act team, which is a wonderful supportive behavioral health team, and they've helped him find housing in a completely separate part of town, and he's doing much better since he's been engaged with them. So I don't think we'll have future incidents.
And Mr. Ham, does the prosecution still want to go with the balance suspended on all 3 cases?
Yes, Your Honor, and to stay away from the Chevron. Nope.
All right.
Okay.
So basically, with regards to, I understand they're all concurrent.
Yes, Your Honor, they are correct and current.
And it's 12 months to serve 30 days, credit for time served 15 days, balance suspended, and stay away from the chevron, correct?
Yes, Your Honor.
Ms. Vigiletti, do you stipulate to the factual basis, venue, and ID for all three cases?
We do, Your Honor.
Mr. Bolden, have you consumed any medicine or alcohol recently?
No, Your Honor.
And have you understood what's going on in all your three cases?
Yes, Your Honor, stay away from the Chevron completely. I moved to a different side of town through a housing authority program with Credit 18. I now live in Buckhead. That was just happened to be the local store, Your Honor. And I would just get the local groceries and things like that. I never was begging for anything like that outside the store.
Are you satisfied with your legal services?
Absolutely.
If you decide to plead guilty to these three cases, you would have to give up your constitutional right to a trial in front of a judge or jury. You will not have the opportunity to confront your accuser, challenge the evidence brought against you, present your own defenses and arguments, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am. Yes.
In case, was that a yes?
Yes, Your Honor.
So you plead guilty to all three counts of criminal trespass, correct?
Yes, Your Honor.
With regards to the case ending in 33708, your sentence is 12 months to serve 30 days, credit for time served 15 days, balance suspended. You are to stay 200 yards away, that's the length of 2 football fields, from the Chevron at 4485 Washington Road in Atlanta, Georgia. With regards to the case ending in 21228, it will be a 12 months probation concurrent to the first case, balance suspended. With the case ending in 24 CR 3024A, it will be 12 months concurrent with the first case, balance suspended. If you are caught sight anywhere near the Chevron, at its parking lot, on the sidewalk, or in the store, they are more than welcome to call the police and have you arrested and brought back to jail. Thank you.
Thank you, Your Honor.
Jail Court Eidfeld, we good for now?
We're good. No one else
Thank you.
is here.
Courtroom 2?
Hey, Miss Blunt. Miss Blunt.
Yeah.
Can you call McLeod for
Yeah.
Okay. And Your Honor, this is gonna be position
No,
30.
I'm going down to 3 South to do him.
Okay. This is gonna be position 30 and 31, Mr. Samuel Streeter.
And Mr. Ham, any additions? I'm getting cautious and asking this out of abundance of caution.
No additions, Your Honor.
Oh, thank you, Ms. Okay, thank you. All right. This is Samuel Streeter, position 30 and 31, case 23 CR 8078B. Mr. Streeter is charged with theft by shoplifting, 2 counts of simple battery and willful obstruction of a law enforcement officer from June 2nd, 2022. He's got a bench warrant matter 24 FTA 692. Mr. Streeter, you've been advised of your right to remain silent, and your attorney is Ms. Vigiletti. May I place you under oath for purposes of this plea? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Ma'am, yes, ma'am.
Okay. Ms. Mokeke, what's the recommendation?
The state's recommendation for count 1 is 12 months served 45 days, credit for time served 11 days, balance probated, stay away from all Kroger locations, no further contact with Kevin Bernard and Teosha Adams, a $500 fine, anti-theft course, and 40 hours community service. For count 2, that is going to be 12 months probation to run concurrent with count 1. For count 3, that will also be 12 months probation to run concurrent with count 1. For count 4, that will be 12 months probation to run concurrent with count 1, as well as a $300 fine. And I would just like to bring to the court's attention that this defendant does have 63 arrest cycles. He does have some theft by shoplifting convictions from 2023, 2018, 2003, and a theft of service from 2004. And then he has several theft by shoplifting arrests, 2 from 2017, 1 from 2018, 1 from 2019, 1 from 2020, 1 from 2022, 2021, and then 2 more from 2020.
Okay. Ms. Vigiletti?
Yes, Your Honor. We'd like to discuss the possibility of a non-negotiated plea this morning, with the only point of contention being additional jail time. As it stands right now, the offer would require 12 more days in the jail for Mr. Streeter, who has already been here for 11 days. And the reason we're requesting a reduction to time served or something close to it with all other requirements remaining the same is because Mr. Streeter has recently made some changes in his life, as I'm sure you could see from the documentation. His criminal history is related to primarily alcohol and addiction. And, you know, he was unhoused for a while. He recently moved in with his sister, Christine, who's a great stabilizing force in his life. I have a stable address for him and a phone number, and he's working. He's been doing warehouse work. And because it's through a temp service, they can always reassign him. He's just eager to get home and get back to work, get started on this probation. He's full understanding, staying away from all Kroger, taking the anti-theft course, doing his community service. We discussed places he might be able to get that done today. And of course, paying that $800 fine will be a significant task for him. So he just wants to get going, get started on this.
All right. Ms. Mokeke, when was his last arrest besides this bench warrant? You said he had over 60 arrest cycles.
Yes, I think it was 2022, but I just want to double check.
Ms. Tyson, if you have that information.
Yes, Your Honor. Looks like he had a failure to appear arrest in McDonough, Henry County, August 17th of 2023. That was his last arrest before this failure to appear arrest.
And Your Honor, I'll just say his failure to appear, he tells me, was because he was incarcerated. He did spend a bit of time in Harrison County, about a year, which was a significant pivotal point in his life.
Yeah. Mr. Streeter, you have a extremely long criminal history record. And in all good conscience, I cannot consider a reduction of jail time. I'm going with the state's recommendation. What would your client like to do?
Mr. Streeter would like to enter a plea today, Your Honor.
And do you stipulate to the factual basis, venue, and ID, Ms. Vigiletti, for purposes of this plea?
We do, Judge, and I did just want to ask if you'll consider waiving some probation fees with the understanding that these two fines together do add up to $800.
I will waive the first 3 months of probation. And I think Ms. James is on probation. Where is she? Ms. Thomas? Okay. I just want to make sure that they note that it'll be a 3-month probation waiver, but you're not going to like what I'm going to say. Okay. Mr. Samuel Streeter, have you consumed any medicine or alcohol?
No, ma'am.
Have you, are you satisfied? Have you understood the proceedings so far with regards to your case?
Yes.
Okay, you have to speak up, just not nod your head.
Yes,
And are you satisfied with your attorney?
very so.
If you decide to enter this plea, you understand that this will be additional charges on your criminal history record,
Yes,
which is significantly lengthy.
yes.
And if you decide to enter this plea, you understand that you'll be giving up your constitutional right to challenge these charges in a court of law before a trial, in a trial before a judge or a jury.
Yes.
That would include waiving your right to confront your accuser, challenging the evidence brought against you, being able to present your defenses and arguments, and being able to, and having the state carry its burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to 1 count of theft by shoplifting, 2 counts of simple battery? Mr. Streeter, you know and I know that you have a lot of charges. Please let me finish.
Oh, yes, ma'am.
Because I want you to understand that you are not doing yourself any favors today. How do you plead to 1 count of theft by shoplifting, 2 counts of simple battery, and 1 count of willful obstruction of a law enforcement officer?
Guilty.
On the theft by shoplifting, your sentence is 12 months to serve 45 days, credit for time served 11 days. You have additional time to serve at the Fulton County Jail, after which then you will be on probation. While on probation, you will complete an anti-theft class, which you must enroll within 30 days of being released. You must complete 40 hours of voluntary community service at any nonprofit agency, and you must begin by completing 10 hours in the first month and then 5 hours minimum for every month thereafter. You will pay a $500 fine, and you must begin with a payment of $100 in the first month and $50 minimum every month thereafter. You are to have no contact with Kevin Bernard, and you are to stay away from all Kroger stores in Fulton County, Georgia. With regards to the simple battery, 2 counts of simple battery, they will each be 12 months concurrent to count 1. With regards to the willful obstruction of a law enforcement officer, it will be 12 months probation concurrent to count 1 with an additional $300 fine. The minimum fine payments apply, which is your total fine is $800, so it'll be $100 the first month and then $50 minimum every month thereafter until the $800 is paid off. For the first 3 months, while your probation fees are waived, you are going to report to probation twice a month. Do you understand, sir?
Ma'am, yes, ma'am.
This is to make sure that you stay out of trouble and that you understand what you're required to do. During those 3 months, I hope that you take the effort to find a job and make sure that after 3 months, you stop paying your probation fees and that you continue to pay your fines. Thank you.
Thank you.
Thank you, Your Honor.
That's it.
Did he have a bench warrant? Am I going to null cross that? Yeah.
Yes, Judge.
Next, we have position number 7, Mr. Justin Hall. He was in Forsyth Jail, and I spoke to him this morning about the case. Your Honor, we're going to plead not guilty and sign a waiver or submit that. We don't have.
All right.
A bond is moot at this moment, Your Honor. That's
Okay.
all. Thank you.
Mr. Hall, you are charged with simple battery in Fulton County, Georgia, stemming from a December 10th, 2023 incident under case 24 CR 3533C. You've been advised of your right to remain silent. Your attorney is the Public Defender's Office, currently with Mr. McLean. Your attorney is entering a not guilty plea pursuant to a waiver of arraignment, and this case is going to be further notice for trial. In the event that you get released from the other location, please make sure that your address is current with this court at all times and that you report to court when summoned for trial. Thank you.
Thank you, Your Honor. Another one we have left is position 5 on the add-on, I believe.
Position 5.
but just what, yeah, that's a conflict.
All right, in that case, let me see. I have a bench warrant calendar. Is there a Spence Bernard Brown on Zoom? Spence, no? All right. Zavon Medley? Zavon Medley, please unmute and start your video.
Your Honor, can courtroom 2, Kasha, the social worker, and Kia Burgess. She's not logged on.
They're both on.
Oh, Kia Burgess in courtroom 2, be in the breakout, please.
All right, Miss Vigilante and Miss McLean, Mr. McLean, who are they going to be in a breakout with?
Myself, Miss Burgess, and Mr. Tommy. We're trying to work out something on the fees. We're trying to work out something on the request.
Okay,
for fee
and
reduction.
who's representing Mr. Medley?
Your Honor, Mr. Medley listed a private attorney when he went to the clerk's office, and I did send him an email, didn't hear back. Mr. Medley, if you need our services, I'm happy to speak with you.
Right, we had noticed it was Judy Kim on Peachtree Street.
Understood.
Private practice.
All right, just give me a moment. Miss Lewis, please place Miss Burgess, Lakia Burgess and Miss Kasha in a breakout session. And hold on to courtroom 2 for just a second. Mr. Zavon Medley, you have been charged with battery family violence stemming from a January 18th, 2022 incident and case 22 CR 268G. You have a right to remain silent. Anything that you say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one would be appointed to represent you. I understand that you have private counsel representing you. Would that be correct?
Yes, ma'am.
Who's your attorney?
Judy.
All right, thank you. Miss Lewis, you can go ahead and place courtroom 2 into the breakout session with Miss Burgess and Miss Kasha. Thank you.
Okay.
All right, Mr. Medley, is your attorney present today?
No, ma'am.
And why is that?
I don't know. I got a call because I thought she was gonna be here too.
Why would she know that she has to be here unless you've informed her?
Yes, I informed her. She know. She the one who told me to go down there and get my court date rescheduled.
Did you send her the Zoom link in order to be present?
Yes.
Okay. By the time I finish this calendar, she has to be present. Otherwise, you'll need to surrender yourself to the Fulton County Jail on this bench warrant.
Okay.
So you might want to get cracking and find her and make sure you send her the Zoom link. You may stop your video and unmute while you do so.
Okay. Thank you.
All right, with regards to the other case, Spence Bernard Brown. Ms. Lewis, do you see such an individual as on this as a participant? Spence Bernard Brown, if you are not present?
No, there's nobody.
right.
There's nobody.
The request to set aside that bench warrant is denied. He has failed to appear. Okay, Mr. Murphy, you are here for the 11 a.m. calendar?
Yes.
All right. Mr. Bartel, are you available? Paul Bartel?
Hey, Judge Law. So I'm not on the Medley case, but I just got the phone with Miss Kim. She said she's gonna log on.
You're what now?
I'm not on the Zavon Medley case, but I just got off the term with Attorney
Miss Kim?
Kim, and she's gonna log on.
Okay, good. all right, so Ms. Lewis, please let me know when,
I will.
all right, Mr. Walker, can I go into a breakout room with you and Mr. Murphy on the competency calendar, please?
Yes, I'm
Okay.
ready.
All right.
Do I need to put you all in with the other group?
Just Mr. Murphy, Mr. Walker, and myself.
Okay.
Ms. Lewis, can you put me in the breakout room, please?
All right, State versus Zavon Medley. Is Miss Kim present?
Oh, Judge, I haven't got on yet.
Oh dear.
I think he was calling. I don't think he's on yet. He left out the call, so they're both not on yet.
Did he leave the Zoom too?
Yeah, he left the Zoom, the call, I guess, because he was on his phone.
I see. Okay. And is Mr. McLean and Miss Vigiletti still in the breakout with Miss Kasha and Miss Burgess?
Yes, ma'am. They all still in the breakout room.
Okay. And I'm just going to keep up and asking you what's going on. Miss
I
McLeod,
know.
is Miss McLeod speaking to Mr. Robinson on the add-on?
We just wrapped it up. She's getting ready to come back on.
Okay.
Your Honor, I have spoken to Mr. Robertson.
Yes. And
Yes, Your Honor, and we would like to see if we can have his bond modified, Your Honor.
all right. If you can just give me a moment. He was on the add-on calendar.
Yes, Your Honor.
This is position 5 on our add-on calendar, 24 CR 003291Y. Mr. Ronald Robertson is accused of a misdemeanor offense of which we are going to waive the sounding. He was addressed on May 28th, 2024, in which a bond has been set. For the amount of $5,000 by Judge Williams to stay away from all Marta property and no contact with Tisha Evans. Mr. Robertson, you have been advised of your right to remain silent, and your appointed counsel is Miss Maureen McLeod. Ms. Tyson, may I have Mr. Robertson's GCIC?
Yes, Your Honor. He has 37 arrest cycles beginning in 1983. His last arrest was in Savannah, Chatham County. Let's see, June 5th of 2020. And that was for receipt, possession, or transport of a firearm by a convicted felon and carrying a weapon without a valid license, first offense. The GCIC states that the receipt, possession, or transport of a firearm by a convicted felon was null pros March of 2024, and the carrying without a weapon or valid license was also dismissed. That was just dismissed at an earlier date. Most recent violation of probation was in 2018. He has another violation of probation from 2016. And then everything else is outside of the 10-year period, Your Honor.
All right.
Mhm.
I just have one question. Miss McLeod, this case has already
Yes,
been
Your Honor.
used. Would you like me to arraign the case today, or would you like to file a waiver arraignment?
I will file a waiver of arraignment, Your Honor.
Right, please direct the waiver of arraignment to Miss April Champion so that she may place that on file, and the case will
I
be
will do
further
that.
noticed. Yeah, and it will be further notice for trial. All right, so I've already indicated the bond and the restrictions that were imposed about him. What is the reason for reduction?
Your Honor, he's not in a position to post bond at this time. My client is 59 years old. As pretrial has said, he really has no significant criminal history in recent years. He has been struggling in terms of accommodation and all that. And he also denies the allegations concerning this matter, and he tells me this was a situation where he thought someone had passed out, who was in need of help, and he was trying to help them. And he tells me that he called 911. So I think it was kind of a misunderstanding of sorts, Your Honor. And he doesn't have this kind of history. So I think that a signature bond would be appropriate for him, Your Honor. I see no reason why he should not receive one, given the fact that he has no significant criminal history, and certainly not any in the past 10 years.
Yeah, and I do want to add his most recent felony conviction was in 2013, and that was for a peeping Tom in DeKalb County. That's the most recent.
Okay, thank you.
Mhm.
What are you seeking, Ms. McLeod, in terms of amendment?
A signature bond, Your Honor. He's not in a position to post bond, and he doesn't have anyone to help him with bond. So if he doesn't get a signature bond, he's just going to be sitting in jail.
Mr. Ham or Ms. Mokeke?
The state is opposed to the defendant getting a signature bond. He does have the charge that pretrial stated from 2013. Given the nature of the offense, we believe that the bond that he currently has is appropriate. CCTV footage did capture the assault. And also, if you're trying to wake someone up, that is not how you go about waking someone up or seeing if they're okay.
Understood. Ms. McLeod, I'll amend the bond to 1,500. It is a surety bond. Given the allegations of the warrant, given his criminal history record, and given the alleged evidence that the CCTV may produce, that is a reasonable amount. Again, he's to have no contact with Tisha Evans, and he's right now on a ban from all Marta property.
I understand, Your Honor.
Case is going to be further notice for trial.
Thank you, Your Honor. Ms. Mokake, is it possible for you to share discovery with me in this case?
We will go about sharing the discovery.
Okay, awesome, because I'm gonna ask for trial for him.
Oh.
I'll be asking for him to be placed on a jury trial.
Are you
calendar.
filing a speedy trial demand or? what are you
Yes, Your
doing?
Honor, I'm gonna do that as well.
Okay, Ms. Mokeke, the state's on notice that that's what the defense intends to do. So the state's on, you can go ahead and start the process of serving Ms. McLeod any outstanding discovery. Ms. McLeod, please make sure that you file all your requests for discovery, motions and speedy trial demand. And please make sure that Mr. Robertson, let me finish. I've heard you, and I'm going to address you.
Okay.
And Ms. McLeod, please make sure that the demand for speedy trial is a separate and distinct document and separate distinct filing.
Yes, Your Honor.
It's
I
nothing
usually do
against
that.
you, just in prior cases, I don't want any confusion about where such a request is buried.
I usually find out who the division judge is, Your Honor, and I serve it on them. I make
You
sure
want to
it's
sprinkle
there.
it with glitter and put neon lights on it, that's perfectly fine too. All right, thank you.
Thank you, Your Honor.
All right, before you leave, Ms. McLeod, yes, Mr. Robertson, please remember that you have a right to remain silent. Anything that you say in open court, your statements can and will be used against you.
Yes, ma'am. Can I speak?
You can you can ask a question about your bond, but please do not discuss the facts of your case.
Ms. McLeod said y'all offer a plea bargain at 120 days and 40 days or something like that, she said.
I explained that the state wanted you to spend 120 days and the rest on probation. I explained that to you, and you did not want to take the plea.
No, I'll take it. I do the 40 days.
Well, it's not 40 days. I just said in the event that Fulton County gives 2 for 1, then the 120 days would essentially be 60 days, and you have already spent 18 days. I don't know if that is how the state will calculate it. Do you want to go ahead and accept the state's plea offer?
Yes, ma'am.
Okay.
All right. This is going to be additional time at the jail, correct?
That's my understanding, Your Honor.
And Ms. McLeod, you're going to have to submit the paperwork and so forth, and we don't have that at this juncture. So, Mr. Robertson, Ms. McLeod is going to speak with you, and we're going to readdress your case next Thursday for the plea. This is not going to prejudice you because you already have to serve additional time at the jail, and that will be counted towards your sentence. Do you understand?
Yes, ma'am.
All right, and that way you will have a more meaningful discussion with Ms. McLeod. Considering what she intends to do, I think it would be best if you sit down and truly understand what your attorney intends to do for you before you make a final decision.
Yes,
Do
ma'am.
you understand?
Yes, ma'am.
All right, Ms. McLeod, go ahead and file your necessary documents as well as the bond order, amending it to $1,500 surety with the same conditions.
Do that, Your Honor, and I will also go to see him at the jail.
Appreciate it. Case is reset to next Thursday, which is going to be the 20th of June. Thank you.
Thank you, Your Honor.
Mhm.
That concludes my business before the court. May I be excused?
Ms. McLeod, did you have a couple of cases at our 11 a.m. calendar?
Yes, ma'am, she did have some on the competency
Yeah.
calendar.
On the competency calendar,
Yeah,
yes.
I already handled those. I was on the competency and handled my competency matters. Mr. Pierre was my client on the competency calendar.
All right, let me.
Miss McLeod, you probably getting mixed up with Judge Porter. The
Yeah.
ones I sent to you, those are for Judge Porter upcoming,
This is
calendar,
Derek
calendar.
Grigsby. Yeah, you've got a couple on the 11 a.m. and I'm going to take you up very shortly, if you wouldn't mind holding.
Not at all. I don't
Okay.
mind.
Thank you. Mr. McLean, did you have something to announce? Are you on mute, sir?
Thank you. Your Honor, there's some confidential information I need to run past Your Honor, and the prosecutor would be present for that, of course, as well, before
Okay.
I then make a special request on behalf of Mr. Thomas.
Understood. Okay, is Miss Judy Kim on Zoom? No, okay. Miss Lewis, could everyone who needs to be at the 11 a.m. calendar, including Mr. Jamel Ham, Miss Mokeki, Mr. Ian Walker, please start your video. So it will be Mr. Paul Bartel, Miss Kia Burgess, Miss Kasha, everyone whose video is on. And of course, Miss April Champion. Mr. Paul Bartel,
Yes.
there he is. Okay, we'll leave him in courtroom 2 then. Could you
Okay.
place us all in a breakout session, please, Miss Lewis? If Mr. Bartel gets on his laptop, you can put him in as well.
Okay, but not
And courtroom 2, and courtroom 2 too.
Oh, in courtroom too? Okay.
Yes. We'll just go back.
No. Yeah, but it hadn't started yet. So we're gonna break out into this.
It sounds like they're gonna handle this video and then competency right after.
Mhm.
Could even,
All right, I'll take care of it. All right.
are you here for the competency counter, Attorney Murch? Are you here for?
Yes, yes, ma'am. Zephan Medley. Judy, I work with Judy Kim. She's out of pocket right now, and she just called me and asked me to appear
Oh, okay,
for
so you here for the gentleman for the bench warrant?
Yes, Your Honor.
Okay, all right, with the judge, they're in the breakout room at this time, doing another calendar. So once they get done with that calendar, they'll be, coming out. I'll text a message in there, let the judge know that you're here.
I appreciate it. Thank you.
All right, thank you.
You want to talk to me?
Oh, hey, Mr. Medley?
Do you need a
Yes.
breakout room with him? Do you need a breakout room to talk to him?
Yes, ma'am. If we could have one, I'd appreciate it.
Okay.
What?
they're all still in the breakout room, so it's gonna be a minute. But I did let her know. I got your message. I just saw. So I already let them know, so. Attorney Carlos. They're on their last case in the breakout room, so they're about to be coming out shortly.
Okay, we are addressing our bench warrant calendar for today, June 13th. If folks would just give me a moment, please. Let's get to that calendar. Oh dear. Is Zavon Medley on Zoom? Yeah.
Yes,
Mr. Carlos Mucha, good afternoon. Who do you represent, sir?
Good afternoon, Your Honor. I work with Judy Kim. We represent Mr. Medley.
All right, good. So, Mr. Medley, as I already indicated to him, he's got a bench warrant. In this case, 22 CR 268G, in which he's got a misdemeanor charge for battery, family violence, stemming from a January 18, 2022 incident. He was released on a pretrial bond on January 20th, 2022. He failed to appear at the calendar on April 26, 2022. An arrest warrant was issued on June 14th. And he's got a bench warrant presently in which he'll be required to report to the Fulton County Jail. Yes, Mr. Mucha. And your client has been advised of his right to remain silent and so forth.
Yeah, yes, Your Honor. Thank you. Yeah, Mr. Medley was arrested, I believe at the beginning of 2022 on this charge. At that time, that was his home. His life kind of spiraled. He became homeless, didn't have employment. He was living on the streets until he didn't pick up any arrests since then. It didn't break the law. He found gainful employment last year, and he was able to save money, and now he has a home to live in. And he wasn't arrested on this bench warrant or something else. He voluntarily came in because he's trying to get his life back on track. So we'd ask the court if it would lift the bench warrant, and we can waive the arraignment today and get his case forward so he can get this resolved.
So he was required to stay away from 3110 Godby Road.
Yes, Your Honor.
And he has been residentially challenged since then, or
Yes,
where
well,
did he
he was
find
rest-
housing?
he did find housing, I believe at when I spoke to him earlier, he said at the beginning of this year. So in 2024, he did find housing. And even before that, he found work. So he was working since the fall of 2023, and he now has a home since beginning of this year. And, he voluntarily, as they came into the court to, face the music on the 2022 charge. But, like I said, we'd asked that the bench warrant be lifted and he be able to proceed, on the calendar.
All right. I set the bond on this matter at 7,500 signature bond through pretrial services. And I'm assuming that even though he was residentially challenged, he never reported to pretrial, or did he report to pretrial?
That I don't know. Mr. Medley, if you're on, did you report to pretrial?
No,
Raise your right hand.
never-
Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge? It was
Yes, ma'am.
January 20th, 2022. I gave him a release bond. He was required to report to pretrial once a month. He was required to enroll into a 12-week anger management class, and he was not allowed back at the location. In fact, a third party was permitted to retrieve his belongings. So I clearly found this case to be somewhat egregious, and to the effect that I wanted him to have absolutely no contact with Jamie McDonald. So, Mr. Medley, did you report to pretrial?
No, ma'am.
So
when
you
I
did
had got
absolutely
out-
nothing?
No, ma'am.
Okay. Anything from Mr. Ham?
We would oppose the reinstatement of the bond, and we request that he surrender himself on the bench warrant as currently stated. It seems as if he does not follow the judge's directions and orders, even if he did not have a place to stay. He still was required to report to pretrial. He did not do that. Based upon his inability to take this matter seriously, we request that the bench warrant stay in place.
Understood. Thank you. Mr. Mucha, do you have anything else to add?
Well, Your Honor, I think he is taking it seriously now. He's trying to get his life back in order. And yeah, I mean, he should have checked in with pretrial and he should have gone by the steps. But, when their life spirals, it's not just one stop. They keep falling.
Understood.
And, we'd ask the court to recognize that he did come in. I mean, he wasn't arrested doing something else. He's coming forward trying to settle this.
Can I say something?
Mr. Medley, can you explain to me how your life spiraled?
That was the only place. I don't have no family in Georgia. I'm from Virginia. So once I lost that apartment, I really was struggling trying to find a job, struggling. And I mean, it's hard out here. I ain't gonna lie. And once I always knew in the back of my head I had to go take this. I always knew this was serious. So I had to get my I had to get my life right. So I got my money up and I got me a place. I just bought a car. Like, I'm doing real good. I don't be in trouble with the law. As you can see now, I'm facing you now today. I apologize. And I don't want to lose my job. I just got into a better place right now. And I would take this serious if you can let me this one time.
All right.
I mean, it's not too much I could say, but I'm sorry.
Understood, Mr. Medley, but unfortunately, your current bond is through pretrial services. And I'm not about to amend this particular case to a signature bond through the jail, given the allegations in this particular matter. When will you be able to make time to come down to the Fulton County Jail and surrender? Your bond will be amended to $1,000 surety bond, which means that you go through a bonding company And Mr. Mucha, as you understand, he would need to pay a $100 to $200 fee to the bonding company to be released, unless he wants to put up a $1,000 cash bond.
Mr. Medley, you could do that. You could pay $100, $200 to a bonding company.
Yes, sir.
Okay.
Now, the next question is the date. When will you come down to the Fulton County Jail? We have famous people who travel all over the country to come down and be booked in and then be
Yes.
released. So we're very accustomed to it.
Could I at least talk to my boss and let them know what's going on?
You can come down, your boss doesn't need to know. You can come down on the weekend.
Yes. But we work 7 days, almost 7 days a week.
Well, Mr. Medley, I'm going to advise you that
But
you
this
contact the
weekend.
bond-
Are you working this Friday?
Yes,
Will
working
you be able
on
to drive
Saturday.
down after work?
I can catch the bus there.
Okay. You will be required to surrender to the Fulton County Jail this Saturday. And that is June 15th before noon.
So I can pay the bond now.
Well,
Listen
what you
very
need to do
carefully,
is
sir.
you contact a bonding company right after this call, and so it'll be squared
Okay.
away, so your bond will be ready for Saturday morning. Okay.
Okay.
But this is the important part. Your bench warrant is not set aside. You have no legal excuse for failure to comply with pretrial and failure to report to court. You are to report to the Fulton County Jail this Saturday, which is June 15th, 2024, and you must check into the Fulton County Jail at Wright Street before 12 noon. If you have your bond all squared away, then as soon as you are booked in, you will be released on your bond. Do you understand?
Yes. I work night shift, so I get off at about 6, 7 in the morning. So I turn myself in about that time when I get off.
7 in the morning, what day?
You can be there Saturday.
If it's Saturday night, it'd be Sunday. Friday going into Saturday. Friday going into Saturday.
Mr. Medley, I don't know your life. You need to tell me what your work schedule is like, because otherwise you need to get time off from your boss in order to do this.
Yeah. Friday night going into Saturday, so it'd be Saturday morning. Around 9.
Are you working on Sunday?
Yeah, but I could tell them. I'll tell them what's going on. They already know what's going on, so
Okay.
I let them know.
Then I'm going to amend it that you booked into the Fulton County Jail on Sunday, June 16th. Is it 16th or 17th? Yeah, 16th.
16 is Father's Day.
All right. You book in on Sunday, June 16, 2024, before noon.
Okay.
And then you are released on a signature bond, not signature bond, on a $1,000 surety bond. Same conditions apply. While you are at the jail, you are to update your mailing address, email, and phone number in writing.
Yes, ma'am.
And then we will mail you your summons to appear in court next. Mr. Mucha, do you want me to arraign your client's case today, or would you be filing a waiver of arraignment?
Your Honor, we'll be filing. Honestly, we can, if it's easier for you, we can do it now, or we can file the waiver, whatever the court
It
prefers.
is easier for me, and I appreciate that. Please send the waiver of arraignment to Miss April Champion, and that's april.champion at fultoncountyga.gov. Mr. Medley, your attorney is filing a not guilty plea on your behalf. Your case is going to be further notice for trial. And we will send you your summons to whichever address you provide. And you must appear in court in person for your trial.
Okay.
All right, in the meantime, Mr. Ham and Mr. Mucha, you can discuss this to see whether a plea offer may resolve the case. And if so, you can have the case placed on any of our Tuesday or Thursday calendars via Zoom.
Okay. Thank you, Your Honor. And I'll have, like I said, I'm appearing for Ms. Kim, so I'll have Ms. Kim contact.
Understood. Thank you. Mr. Medley, do you have any questions?
No, ma'am.
Please remember to surrender this Sunday, June 16, before noon. Thank you.
Thank you, Your Honor.
And Mr. Mucha, send in the proposed bond modification order, because as soon as jail records gets in, it facilitates the process at the jail.
Yes, Your Honor.
All
I will
right.
do that.
Thank you, Mr. Medley. Mr. Mucha, thank you very much for appearing. With regards to the second case, Mr. Spence, I don't believe he has appeared. So that bench warrant is request to set aside is denied. All right, courtroom 2. Ms. Vigilante, anything else to announce? Otherwise, we'll go down the calendar.
I have a couple of announcements related to people not present, but we can do so as we run the calendar, Your Honor.
Understood. Thank you. On the bench warrant calendar, on Mr. Medley, the request to set aside the bench warrant is denied. It's surrender on this Sunday with $1,000 surety, and Ms. Kim will file a waiver of arraignment for the notice for trial. On position number 2, Spence, that bench warrant request to set aside is denied. The defendant failed to appear. On the probation revocation calendar, position 1, Henderson, is commuted to time served. No, excuse me, to continue on probation. On position 2 and 3, Mitchell, those cases are commuted to time served. All right, Ms. Champion will go over the calendar for the SAP and the add-on, please.
Position number 1 on the SAP is reset for the notice for trial. Position number 2 was a plea. Position number 3 was non-pros. Position number 4 was a plea. Position number 5 was a plea. Position number 6 was a non-pros. Position number 7 is reset for the notice for trial. Position number 8 was a plea. Position number 9 is reset for the notice. Number 10 is also reset for the notice. Position number 11 was a plea. Position number 12 was a non-pros. Position number 13, I don't have anything for.
13 and 14.
Your Honor, Ms.
Missing.
Jackson is still at Grady Hospital, we believe.
Any status information?
We have no status information that we know of.
Okay. We're going to reset it to next Thursday's SAP. And please just keep us up to date unless, well, and then hopefully by then you'll get more information about whether she needs to be arraigned or whether you want to file a waiver of arraignment. All right, position 15, Ms. Champion.
Position 15 is reset further notice for trial. Position 16 was a plea. Position 17 was non-pros. Position 18 was reset further notice for trial. Position 19 was reset further notice for trial. Position 20 was reset further notice for trial. Position 21 reset further notice for trial. Position 22 was a plea. Position 23 was non-pros. Position 24 was a plea. Position 25 was a non-pros. Position 26 is reset further notice with a total of a $600 sign-on bond through the jail. Position 27 is reset further notice. Position 28 was a plea. Position 29 was a non-pros. Position 30 was a plea. 31 was a non-pros. 32 was reset further notice for trial. 33 reset further notice for trial. 34 was a plea. And position 35 was a plea. Add-on 1 was a plea. Add-on 2 was a plea. Add-on 3 was a plea. Add-on 4 was a non-pros. Add-on 5 is going to be reset SAP 620. And add-on 6 is reset further notice for trial. Any questions?
Ms. Vigiletti, did you have any announcements other than what Ms. Champion announced?
No, I think that's all accurate.
All right. Okay, folks, thank you so much. We will be in recess until the 2 o'clock C calendar. Thank you.
Thank you.
Thank you.